but it can be in the second.
My lord, I have solved. I have objection, my lord.
My lord,
Let it be taken in any other day, my lord. Not at 2, my lord.
my objection is that, my lord, in item number 1, I am appealing. We have already, regarding impute petition, my lord, we have already filed our
Objection.
the objection that is filed today.
File today.
Today. So along with that, my lord, it will be come up, my lord.
Very well. Then let the matters be listed. Give a date, please.
And moreover, my lord, in
1 to
other
40.
cases, my lord, actually, my lord, that is impute
1 to
petition. Now, my
44.
lord, impute
41.
petition.
Next week,
We have to decide on the impediment, that's all.
Yes, sir.
No, my lord,
Initially.
because of this impute petition, my lord, our case has been delayed, my lord. We are fighting for since 2017 for our salary, my lord. Last 9 years, my lord, although we are, my lord, regularly appointed, we are not getting salary. So my issue is totally different.
You give a date. You file
So,
it.
my lord, no, why regarding that other matter, my lord, only one matter they have filed a impute petition. Other matter, my lord, they are already fixed in another date, my lord. So in that case, my lord, they have not, government have not filed,
When is it fixed?
my lord.
When is it fixed?
All the matter will be taken up on 30th, my lord. 30th.
But in all cases, there is no impute petition, my lord. Only one case there is impute petition, my lord. And because of
When-
that, my lord, others are suffering, my
No,
lord.
when is the other lot of matters fixed?
That is what 40 is already over.
4 weeks is over. Let it be on 9. 9 May
Not sir. 9th May, Thursday.
or 9th, 7th is the election day, right?
7th is holiday.
14th. 14 May.
My lord.
14 May.
Can the salaries be considered
These
also?
matters of the joint request be listed again on 14. As per report.
Yes.
Item number 1 to 41.
1 to 41. Mr. Goswami, matters
Yes,
will be
Lordship.
listed on 14.
No, I understand, Lordship, that is regarding the implement, but as my learned senior friend, colleague, Mr. Mohanda was saying, now that the approval has come, let the salaries be released, Lordships. There's no question of these people. Lordship will kindly see the order dated 18/12/2023. Last time also I wanted to bring this order to your Lordship's knowledge. Attention, 18/12/2023 order, Lordships.
See, the problem is somebody filed an objection today, and this is not
No.
connected to the main petition.
No, that is with respect to implement. We are
Correct.
I am saying about release of salary, which all this while was not released because the government was saying that approval was due. Now the approval has come. They should be paid.
Yes.
The sanction has come. Now the process is on. Now the model code of conduct
No,
has
let
come
the
in, my lord. That's the
salaries
difficulty.
be
We have
released,
to
In
Lordship.
stop
court
naming.
case, there is no model code of conduct. In court case,
No,
no model code. of conduct.
No, where is the
Possibly-
model code of
possibly
conduct
speaks
coming
on-
in here? Please see the order dated
Now we have to make a process. The process
18/12/2023.
has going on. my
Please
lord.
have a look at the order of 18/12/2023, Lordships.
Yes.
May I just read it?
Yes, please.
Mr. B. Gogoi, Learned Standing Counsel Finance, has placed the communication dated 14/12/2023 and submitted that the proposal contained in e-file number so-and-so is under active consideration of the department, as the matter requires proper evaluation for sanctioning of the proposal for filling up 1216 numbers of assistant teachers under BTC area. It is further submitted that the 421 teachers who have claimed not to have received any salaries are also included within this 1216 number of assistant teachers under PTC area. He therefore submits that if the department decides to approve the proposal, then the prayers for release of salary, including the 421 teachers, will be covered. As such, he prays for further time to complete his instructions. Thereafter, please see the next order. 1/2/2024 order. I'm reading in deference to the order dated 18/12/2023, Mr. B. Gogoi, Learned Standing Counsel Finance, as well as Mr. S. Bora, Learned Standing Counsel BTC, submits before the court that the proposal placed before the Finance Department by file number E so and so has received the sanction. Person to sanction receive the Secretary of the Government of Assam, Department of Social Education, inform the Director of Education, BTC, conveying the approval of the government in Department of School Education towards filling up of 1216 number of vacant posts of LP and UP schools in the BTC area as per proposal put up by BTC, subject to conditions mentioned in communication dated 29/12/2023. Now, this being the position, my request, which I wanted to, which I prayed last time also, at least these people are not being paid. If your lordship will see the chart,
You
for 7-8 years.
bring up the status of release of salary by the next date fix.
Exactly, my lord. Exactly, my lord. Last 9 years, my lord, these teachers, my
We
lord, they
need
are
to know
suffering.
what is the status.
no, that status is recorded in 25/7/2023 order. Status is already recorded by this court.
Yes. No, what
Please.
steps have been taken for release of the salary?
No, only a
What is the status
effective order
today?
by your
What is the
lordship.
status today?
Not-
Otherwise,
Otherwise, when the process is on,
That is,
but
What is this
subsequently after
process? I
model
don't know
code
what
of
is
conduct come in,
no model code of
that,
conduct.
that,
Where is the
all the
question?
officers are within the
No, no. Does it mean that the officers are not getting their salaries?
officers are getting their
Then-
salary. That's
The
my
model
instruction.
code of conduct is not to say that the salaries of persons who are otherwise eligible should not be released.
The process has to be done, my lord. The process was
So
on.
you do the process.
Process. Not
This is
in
under
the
orders of
meantime,
the
we'll get the updated instruction, my lord.
This is under orders of the court.
And only 421 of them, lordship, everyone else has got.
my lord, in fact, my lord, they have not complied
Across
with the court
420,
order.
we wanted to,
You take down that as per the submissions of the Learned Standing Council BTC, the sanction for release of area salary.
post has been sanctioned, 226 posts have been sanctioned. Now the
No, that
process
is
is
not 226, my lord, they are.
1220.
The sanction for
1216.
My lord, they are regularized in 2015. To till today, not, my lord, they are diverting, my lord, yet there is several orders from
Absolutely.
this honorable court, my lord, to pay the salary. They have not complied with. Your lordship can just fit case to, my lord, take so much contempt against them, my lord.
the salary sought to be received, the sanction in respect of the salary as well as the posts have been received. However, because of the model code of conduct, the steps have not been, steps although initiated could not be completed. Such submissions are strongly objected by Mr. T.J. Monto, Senior Counsel, assisted by Ms. R. Devi and other counsels for the petitioner, as well as Mr. M. Goswami, Learned Counsel, appearing in for some of the writ petitioners. Stop. It is submitted that there have been directions from this court requiring the department to release the salaries and which have not been carried out. Stop. Let the government, let the BTC, is it the BTC?
BTC.
Yes.
The BTC.
It is the
BTC.
BTC.
Place on record by the next date fixed the status of the steps taken by them for towards release of salaries as well as for release of salaries for the writ petitioners as has been directed earlier by the court. If the court finds that in spite of orders, steps have not been taken by the BTC for release of salary, consequential orders may be considered to be passed by the court by the next date fixed.
Deeply.
Placed on 14th,
14th May.
14 May.
Right.
Mr. Goswami.
Very well, very good. Grateful.
Please, your lordship. I pray for lordship listing of an urgent matter for tomorrow, lordship.
What is the urgency?
My lord, petitioner was originally attached to some other school. Now, as per DC's order, lordship, he revert back to his original school. But the headmaster of the school, he did not allow the petitioner to join in that school, and petitioner is hanging now.
All right, tomorrow. Yes.
That is a lordship. Lordship, I beg to mention for listing of the writ petition for Monday, lordship.
Why? What is the matter?
Matter is pertaining to a frequent transfer matter, lordship.
New matter, old matter?
New matter, lordship. We have filed today.
You have filed today.
So we
So
have
it
to
will
file,
come on its own.
maybe, lordship, but
Subject to clearing of defects. You have filed today, it should come by latest by Wednesday.
No, Lordship, no, it is urgent actually.
Urgent. All right, list on Monday,
Yes.
subject to clearance of the defects. Mr. Dhor, we requested for the records. Yes, it skipped my mind that the records would be relevant.
I have handed over.
Obliged.
Yes.
Me, please, Your Lordship. Lordship, I would like to mention for listing of an item for tomorrow. The urgency is that the petitioner here is pertaining to the selection of an office peon in District and Session Judge Bongaigaon. He was there for from 2015 and on a contractual basis.
Is it a fresh matter?
Yes, Lordship. We have
Let it
filed.
come next week.
No, Lordship.
What is the urgency?
The interview is on Monday. We have filed it before Bihu vacation, but due to some technical issue, we had to withdraw it. And the interview is on
No,
this
what is
Monday.
interview is on Monday?
Yes, Lordship.
He's still working.
He's still working, but
Is he also participating in the interview?
yes, Lordship, but he's not allowed to participate on the ground that he is overqualified. But he is on the service since 2015 on contractual basis.
All right, give it. Monday. You want it for Monday?
Tomorrow, Lordship.
Tomorrow. Okay, tomorrow. Yes.
In fact, my lord, my part was.
My lord, before he starts, my lord, can be taken after some time, my lord. Because Mr. Chaudhary will be increasing your law, assisting your lordship, and he looks up a pardon matter in court one. After some time, my lord.
Can't commit after some time. We can have it in the second half if you want. Or we can hear Mr. Chaudhary if you want to address.
Is also on next month.
So he's right behind you.
Let it be at 2 o'clock. Because my submissions will partly also depend on what Mr. Ken Chaudhary has.
So far as Mr. I. Chaudhary is concerned, my lord, on the last occasion I said, my lord, I am not arguing on the part
But
of
you can't
Malafide.
stop him from submitting.
Sorry, my lord.
You can't stop him from submitting.
No,
If he wants to submit, he'll submit.
no, that's true, my lord.
Yes.
But that was the thing.
The primary
that-
primary trust against me that he has given up. So
So that,
my area will be very
because
limited.
my grounds are sufficiently substantiated from the records, my lord, whatever has been produced by the university, my lord. So it
Very good.
can be taken up after some time, because there is some urgency in the matter, and
We'll call it up at the end of this list or in the second half, whichever is earlier. All right?
Obliged.
Lordship, in terms of the order dated lordship. uh, 1/3/2024, lordship. His father has participated in the disciplinary proceeding.
Yes.
Participated.
Mr. Counsel, you're supposed to apprise the court.
I was not aware, Your Lordship, because my father died, Your Lordship.
Ah.
I was not aware.
If you're not aware, then if the departmental inquiry is there, then what is the conclusion? Dismissal.
Dismissal.
What does your record say in terms of service of notice on the
Sir,
employee?
he participated.
He participated.
Part-
Oh, he participated. Then
That was not.
so what
not
can be
aware.
done now?
Statement for there.
So what can be done now? What is the period for appeal? 1 month.
Yes.
The discipline and appeal would be-
TCS.
Yes.
Lordship, because I was not aware, Your Lordship. After the demise of my father, Your Lordship, my mother was.
So what is your submission now?
I may be given the liberty to challenge the dismissal order, you know.
Yes, okay. Heard learned counsel for the petitioner. It is submitted that since a disciplinary proceeding was instituted against the late husband of the petitioner, dismissing him from service with effect from 27/9/1989,
18.
and the petitioner was not in the knowledge of the said disciplinary proceedings instituted against the late husband of the petitioner, no steps could be taken to assail that order. Stop. fact remains that the disciplinary proceedings are not under challenge in the present writ petition. Stop. In that view of the matter, the learned counsel for the petitioner does not wish to press the writ petition any further, but however seeks liberty to challenge the proceedings, disciplinary proceedings instituted against the late husband of the writ petitioner as per provision of law. In that view of the matter, the writ petition stands dismissed as not pressed. Interim orders, if any, stands vacated. Mr. S.S. Roy appears for the respondents.
All the
All the respondents. Dismissed.
Obliged.
May I please, Your Lordship? This matter, pardon, cancel the suspension order. And on last occasion, the respondent have take some time to file an affidavit.
Who's for the respondent?
Goes to welfare department.
Yes, who's for the respondent here? Director of Social Welfare, who's there? Social Welfare? Petitioner under suspension for 3-4 years now. 5 years. Is she under suspension today? Is still under suspension?
Yes.
You get instructions, find out, madam. Take it up in the second half.
Or else any next date.
No, no. Let's see what instructions. come.
Obliged, Your Lord.
You'll take it up in the second half. Yes.
If the instructions are still awaited.
What instructions?
Lordship, regarding the claim of the petitioner, whether area salary has been paid or not.
Why is it awaited?
Lordship,
Why is it awaited?
we have communicated, but we are still.
You want to inform your clients that we'll drop contempt proceedings, or they will provide instructions.
Lordship, there are two things, Lordship, here. Firstly, the Lordship, as per verbal communication from the department, there is a departmental proceedings drawn against the petitioner. So perhaps they are preparing the instructions, Lordship. Otherwise, Lordship, the petitioner has relied on one rule, FR 54B. But Lordship, if Lordship goes to the rule, it applies only to persons who have been retired during the period of their suspension. In the petitioner's case, Lordship, he has not been retired.
No, his pay has not been fixed. Why has it not been fixed? Accountant General, anything to submit?
My lord, here we do not have any instruction so far because it will concern department only, my lord. To see all these things, any proceeding is pending or not. Because last order, your lordship will get 14/3/2010 from Mr. M. to me. He was submitting that some department proceedings is going on.
You get it by next week. We are giving you one final opportunity.
10 days maybe.
Not 10 days, next week. None appears for the writ petitioner on hold. Mr.
U. Sharma on behalf of Mr. K. Goa.
U. Sharma appears on behalf of the department. What is this department? PNRD.
Lordship, PNRD.
PNRD. Mr. C. Borwa for accountant
My
general.
lord.
Mr. R. for Pujari for finance. The learned standing counsel, PNRD, is permitted one final opportunity to obtain the required instructions in the matter. Matter be listed again next week.
Lordship, in this matter, by order dated, my lord, 14/2024, they were directed to file affidavit, my lord.
No affidavit filed.
No, they have not filed.
Yeah, my lord. Only because the respondent votes because the last occasion, some other council newly are engaged. Anyhow, because regarding this petition, the last order I have seen that 14th it is that my lord and friend has got this one, pension benefit. Pensionary benefit is include GIS and GPF. Now GPF, this other part has got it, but the GIS has been not. If so, this is concerned department will look into matter regarding GIS.
Not GPF, we have received the leave salary.
No, here it is with the
GIS is due, my lord.
GIS due only. If so, my lord, that is
Group insurance.
Group insurance scheme. That is concerned department will look into.
Which is the concerned department?
That is concerned department TSA.
Food.
Food and supply.
Civil supply. Food and
Who is for food and civil supplies?
government, I think.
Government actually नहीं क्या बोलेगा?
Yes, Mr. Sutia.
खबर तो ले लेता है.
Lordship, last time is a CS Hajarika.
Where is Mr. C.S. Hazarika? Council who appeared.
He is another court mandate.
This is the problem. His name is recorded. He was required to file an affidavit.
I will obtain instruction. 47.
Mr. T.C. Sutia, Learned Counsel, Senior Government Advocate, Additional Senior Government Advocate, prays for further time to file affidavit in the matter. MSB Bhuya, Learned Senior Counsel, assisted by MS M. Chakravarti, and appears for the petitioner, Mr. C. Borwa for the Accountant General.
I appear for finance.
Mr. Arbor Purdari for finance. It is submitted that the petitioner petitioner did not receive his GIS benefits. Respondents will obtain the instructions and file affidavit by the next date fixed list after 2 weeks on a date to be fixed by the registry.
As well as lost area salary, it's indicated the area.
GIS as well as area salary.
May I please, Your Lord?
Yes, Mr. Halim.
The matter relates to ROP-based salary, my lord. As per cabinet decision, we are entitled for it. It is not given. As per earlier order, they have filed affidavit, my lord. May I take your lordship to the affidavit, my lord?
Yes.
Paragraph 5 may kindly be seen, my lord.
Paragraph 5. Yes.
Lordship got it. May I read, my lord?
Yes.
That subsequently on 15/10/2022, a review meeting of Adarsha Vidyalaya Sangathan Assam was held, wherein a resolution was adopted that the benefits of ROP shall not be applicable for teaching and non-teaching staff of Adarsha Vidyalaya who are engaged on fixed pay basis, as their entry point stroke engagement procedure differs from the other staff. My lord, my submission is that we are entitled for the ROP based salary as per cabinet decision, my lord. Your lordship may kindly take to page 82 of my writ petition, my lord, the cabinet decision. Last but one paragraph from bottom, my lord. Necessary budget provision will also be made in the state budget to meet the recurring and non-recurring expenditures for operationalization of 46 Adarsha Vidyalayas may be extended by Government of Assam as a future policy decision, which includes payment of salary and honorarium for the officials of Adarsha Vidyalaya Sangathan, payment of salaries to the teaching and non-teaching staff of Adarsha Vidyalaya as per ROP, except daily wage worker. My lord, kindly see, categorization is specific, my lord. Cabinet has specified who will not get and who will get. Now, my lord, they are annexing the minutes of the meeting of Adarsha Vidyalaya, my lord. Your lordship kindly turn to the affidavit at page 94, my lord. They are taking the plea of this particular meeting.
You are what, teaching or non-teaching?
Non-teaching, man. For a moment, may I take your lordship to page 94?
You read the entire cabinet memorandum?
My lord.
Cabinet order.
Notification dated 28/10/2021, my lord. In pursuance of the cabinet decision taken in the meeting of the Council of Ministers held on 24/9/2021 in the conference room of State Guest House, Koinadhara, Khanapara, and for effective administrative control and monitoring of Adarsha Vidyalayas functioning as on date under Samagra Shiksha Assam, the government of Assam, after careful consideration of all aspects, is pleased to notify Constitution of Adarsha Vidyalaya Sangathan Assam for operationalization and management of Adarsha Vidyalaya, and the said Sangathan will act as an autonomous body under Secondary Education Department, Government of Assam. The Adarsha Vidyalaya Sangathan Assam will be a registered society and shall be registered under relevant provisions of Society Registration Act 1860 and will be regulated by following the Memorandum of Association and the rules as annexed herein as Annexure 1 and 2 respectively. Further, one model school shall be established in each legislative assembly constitution. Necessary budget provisions will be made in the state budget to meet the recurring and non-recurring expenditures for operationalization of 46 Adarsha Vidyalayas may be extended by Government of Assam as a future policy decision, which includes payment of salary and honorarium for the officials of Adarsha Vidyalaya Sangathan, payment of salaries to the teaching and non-teaching staff of Adarsha Vidyalayas as per ROP except daily wage worker, introduction of hostel facilities for teaching and non-teaching staff, office expenses, other contingencies, maintenance grant, and all essential expenditures as may be required for smooth functioning of the Adarsha Vidyalayas and Adarsha Vidyalaya Sangathan Assam. Besides, there will be continuation of service of teaching fraternity of Adarsha Vidyalaya till attaining the age of 60 years, subject to the satisfactory annual performance report, entitlement of contributory provident fund, benefit for teaching staff as per norms, entitlement of casual leave, earned leave, maternity leave, childcare leave, and other holidays as entitled to regular employees under GOA and leave CCL, and the other holidays as entitled for regular employees under Government of Assam and entitlement to avail bank loan facilities with due approval of the government. Further, the Adarsh Vidyalaya Sangathan Assam is empowered to generate additional funds for the Sangathan as Vidyalaya Nikhil Nidhi with due approval of government, which will be utilized for the Adarsh Vidyalaya Sangathan Assam and the schools under it as per provision of the executive committee of the Sangathan. This notification will come into force immediately.
Yes.
Yes, madam.
This is a clear decision taken.
Yes, madam. This is a decision, this is a cabinet decision to constitute Adarsh Vidyalaya Sangathan. And this Sangathan is a registered society, my lord. And subsequently.
So to make provisions in the state budget.
Yes, my lord. State budget for the purpose of giving salary and other expenditures.
As per ROP.
As per ROP, but there was a mistake while doing this, my lord, because this non-teaching staff, they are a contractual teachers, my lord, for 11 months. And the teaching staff, their service for till they attaining the age of superannuation, my lord. So subsequently, Adarsh Vidyalaya Sangathan Samiti took a decision not to extend that benefit to the non-teaching staff, my lord. Accordingly, that resolution was taken, my lord.
Now, my lord, my submission is that whether a cabinet decision can be altered by Adarsh Vidyalaya.
That cabinet decision was only for the purpose of constitution of the Adarsh Vidyalaya Sangathan, my lord. Because the entry to the service is totally different, my lord.
Constitutional mandate does not permit it, my lord. So for my understanding, my lord, as per Article 164, my lord.
See, you will have to get a clarification here because once a decision is taken, you have to implement it. With the question of revisiting the decision, are you empowered to do so?
This cabinet decision.
You are not given the liberty to take a further decision. If you come to the paragraph, it is necessary budget provision will be made, which includes payment of so and so, payment of salary for teaching and non-teaching, except daily wage.
Yes.
They are not daily wage workers.
They are not daily wage, but they are contractual, my lord.
But this is not dealt with.
As regards the non-teaching staffs are concerned, they are contractual. But teaching staff, they are not contractual, my lord.
That is not categorized in the cabinet decision.
Maybe, my lord, the decision is not properly worded, but the motive behind is to give
you have to go through that cabinet memorandum. Where is that cabinet memorandum? Why have you not produced it so far?
Well, that I will open, my lord.
That cabinet memorandum will reflect what was placed before the cabinet.
Yes, my lord. That I will open.
How is this decision even relevant without the cabinet memorandum? Where is that affidavit?
Affidavit, my lord, I have filed it on 21/3.
One is the Adarsh Vidyalaya.
4/3/2022.
One additional affidavit I have filed, my lord.
4/3/2023.
Now this contract is subsisting.
Yes, my lord.
But again, ROP, does it include the contractual employees? The scale of ROP is meant for regular employees who are working.
But the cabinet decision does not categorize it clearly.
May not categorize. It did not categorize because it is inherent, implicit. You produce that cabinet memorandum.
Yes, madam.
But if what the learned council has all pointed out is not before the cabinet, where was the need for a review meeting? You have taken a review meeting because you wanted to review that decision.
But because one of that
No, but whether you are empowered to take a review decision, you're not empowered. Anyway, produce it. Let us see. But this review decision, prima facie, doesn't appear to be correct. Let him produce the cabinet memorandum. Mr. N.J. Khatoniya, learned counsel to the petitioner, will file necessary affidavit to bring on record the cabinet memorandum in respect of the decision taken by the cabinet and communicated by order dated 28th of October 2021. Stop. Same may be brought on record by filing necessary affidavit. The cabinet memorandum may be placed before the court to show the proposal that was placed before the cabinet, resulting in the decision communicated by way of the communicated by the order dated 28th of October 2021. Placed again after 2 weeks. Mr. A. Salim appears for the writ petitioner.
One date may kindly.
After 2 weeks.
Any date, my lord.
15th.
15th. I am obliged, my lord.
15 May.
My lord, I appear for the finance department.
Mr. R. Bor Pujari appears for the finance department.
My pleasure, Lordship. Lordship, we have received the instruction on today. Some time may be granted to file affidavit.
Mr. Medi.
Appearing for Accountant General.
What is your first name?
KK Medi, appearing on behalf
KK.
of KK.
KK Medi, learned counsel, appearing on behalf of
Mr. S.K. Medi.
Mr. S.K. Medi, standing counsel, Accountant General, submits that instructions have been received today. He'd like to bring it on record by way of an affidavit. Praise for 3 weeks' time.
2 weeks.
2 weeks' time. Mr. What is your name?
My name is Jay Abbas. I'm
J.
appearing
Abbas
on behalf
appears
of
on
Ego.
for the writ petitioner list after 2 weeks.
Bless.
Yes.
Please, my lord. In this case, my lord, we are led by Mr. Senior Counsel, Mr. D.K. Mr. All of us have withdrawn a Wakalatnama. And all of us have withdrawn the Wakalatnama as well as the files were already handed over to the parties.
You are no longer there.
No, my lord.
Okay. It is submitted by Mr.
B. Das, my lord.
B. Das, learned counsel, that the Wakalatnama has been withdrawn in the writ petition from on behalf of the writ petitioner.
Appelling.
On behalf of the appellant. This is an appeal against CLG.
Yes.
CLB.
Under the old act, Lord, 10F appeal.
CLB appeal.
Yes.
And accordingly, registry to issue notice to the writ petitioner, enclosing a copy of this order. It is taken after 4 weeks. Mr. Dubey, R. Dubey appears for the respondents.
1 to 4.
Mr. Muzumdar also.
Yes.
You are appearing on behalf of the
For
respondent.
6, my lord.
Appears on behalf. Mr. R. Muzumdar appears on behalf of respondent 6. When did you withdraw the Wakalatnama?
My lord, we have on 5/2/24, my lord. We have sent the notice to them, and after they on 6/2/2024, my lord, they have taken all the files. Well, I have a copy of that same. I can.
Okay. Do you have a copy of the application filed before the registry? Hand us a copy. A copy of the application of withdrawal of Wakalatnama. Addressed to the petitioner and filed before the registry. Has been placed before the court and which is kept in the case reports. Matter be listed accordingly after 4 weeks.
Well, our name may be struck off from the cause.
The names of the counsels presently appearing in the cause list on behalf of the writ petitioner of the company appeal, not writ petition, on behalf of the appellants appearing in the company appeal may be struck off. And names need not be reflected. Names not be reflected in the cause list hereafter.
This was the last dated on 9/4/2024, and petitioner given has been made up. Honorable Court earlier occasion, my lord, he filed against the same transfer order. Earlier order, lordship, can you see page 30? Page 30 is a impugn order, my lord, and court order is 40. 40, my lord.
No, what is the challenge?
Challenge is, my lord, page 30, his transfer order.
Transfer order.
Transfer. He was transferred, my lord, the same district, same, only branch is transferred. One person is retired against this, my lord. This past the order, status quo order was passed, and now we have received the instruction and filed an affidavit recently on the 8th April 2024. Has brought, we are bringing the speaking order. Lordship, kindly see our affidavit. That was the only grievance. He says that his representation was not considered.
Affidavit filed by respondent 2.
Yes. Deputy Commissioner. This is the order of 13 March 2024. In fact, his representation was rejected in the March 2022, only denied. No speaking order was passed. That's why he filed this present.
Who's for the petitioner?
My lord.
Who's for the petitioner?
Petitioner, his name is shown, my lord, Talukdar. He never appeared, my lord, because his representation has been disposed of. Last occasion also, my lord, I was in the 4:30.
Name was shown in the display board.
Agency is necessary, my lord. Election is there, my lord.
All right, we'll list it on Monday.
No, my lord, our agency is there, my lord. He never come, my lord. Earlier occasion also same position, my lord.
In fact, the requisition has already been infracted.
In fact, was otherwise, my lord.
All
right,
has already been redressed.
Page 40.
His sole grievances has already been redressed by the order.
What is his grievance?
My lord, the grievances was that in the earlier requisition, there was a direction to dispose of his requisition.
Page 40, lordship, kindly see.
There was no speaking order to that effect. Again, that lordship,
file this writ petition. After that,
No,
Page 40,
his
Lordship, kindly.
order, his prayer is for cancellation of the transfer order.
As per order, Lordship, kindly see his earlier writ petition, page 40. 19/4/2022 passed this order. This honorable court, the present demands of the petitioner was agreed in the order dated 28/3/2022, Deputy Commissioner Korimgos, by which he is transferred and posted at Food and Civil Supplies branch in a Deputy Commissioner. Same district, same Deputy Commissioner, only branch. And paragraph 5, Lordship, kindly
Okay,
see.
we'll take it up after a while. A.R. Talukar for the petitioner. Mark is present. Take it up after a while. Huh?
Time को ना है.
Yes.
I'm told that Mr. Chaudhary is about to finish there. I just refresh your lordship.
Yes, you refresh our memory.
Yes, my lord. In the meantime, he will come.
Yes.
Now, the petitioner, he was appointed as registrar of Bhattadev University.
Your grievance is he is discharged without notice, inquiry,
Yes, probation period.
because he was in the
punitive.
provision.
Punitive. I'll just try, not like to, last occasion, I just forgot this. I just want to take your lordships with the service particulars of the petitioner, because many a time, the background of the person, it gives, it throws a light on the, the conduct of the person, my lord. If I take your lordships to page 31, there is annexure P1. It's his biodata, and lordship will kindly appreciate the post held by him prior to joining the Bhattadev University. Page 31, my lord, serial number 10, field of, 11, employment records. So lastly, he was in Bhattadev University as registrar. Prior to that, he was in Guwahati University academic registrar. Then in Krishnakanta Hendik Open University, he was professor. Then in Guwahati University, he was registrar, academic registrar. Then in the next page, page 32, he served in Assam Engineering Institute as lecturer. Then again in Krishnakanta Hendik University, controller of examination. So this is his background, Milord. He has held all the important positions with unblemished service record. The problem started after joining the Bhattadev University, Milord. So
this is the technical university.
Bhattadev University, no. They have issued an advertisement for the post of registrar, and the petitioner, he was selected.
Yes.
The appointment order of the petitioner, you also will find page 62 of the affidavit filed by the Bhattadev University. So not annexed with the writ petition. That's why, Miller, I'm referring to the affidavit of the university. Miller.
Page?
Page 62.
62. Yes.
It is dated 25/2/2022. Recruitment to the post of registrar, Bhattadev University.
You're referring to page?
Page 62 of the, it's running page, my lord. page 62 of the affidavit in opposition filed by the Bhattadev University, my lord. It was filed on 14th.
That's not running page. Running page is 72.
I'm sorry, my lord. I'm extremely sorry, my lord. It was given
That is
by
25-4.
25-4, my lord.
Yes.
So it says, I'm glad to inform you that as per resolution of the Executive Council dated 23/4/2022 and subsequent approval of the Honorable Vice Chancellor dated 23/4/2022, you are selected for appointment to the post of Registrar Bhattadev University under general terms and conditions to be regulated by the University Act 2017, the statutes and regulations of the university in force from time to time, and under the following terms and conditions. Name of the post, Registrar, term of office 5 years. Then last serial number 7, you will also will find probation period. You will serve a probation period of 1 year, which may be further extended to another year, after which, on review of your performance by the Vice Chancellor, you will be confirmed in the position for the remaining period of term. So it says that initially he will be in probation for a period of 1 year, and thereafter his service will be reviewed, and thereafter further continuation for 5 years will be decided.
Yes.
After this, Lordship will again come to the writ petition, my lord. Page 36. At that point of time, my lord, I was working in the Guwahati University as academic registrar. So I was granted lien by the Guwahati University, enabling me to join as registrar in the Bhattadev University, my lord.
Yes.
Pending approval of the Executive Council, the Vice Chancellor of DU, Lordship.
Yes. Carry on.
Yes, wide order dated so and so is pleased to grant Guru Prasad Khataniar, academic registrar, Guwahati University, lien extraordinarily without pay for a period of 2 years with effect from 5/5/2022 to enable him to join his new assignment as registrar at Bhattadev University, Bojali, Assam. He is requested to hand over the charge of academic registrar due to the undersigned on 5/5/2022. He is requested to clear liabilities, if any. So, from 5/5/2022, 2 years, this May 5th, this period of 2 years will be over, my lord. That is my anxiety also, my lord. Coming 5th May, it will be over 2 years.
You apply for extension of lien.
Sorry, my lord.
You can apply for extension of lien. You can apply for extension of lien.
Look, normally, employer doesn't permit, my lord, extension of lien, my lord. In extraordinary circumstances, it says, but normally it's not. They don't permit, my lord.
No, I think normally you are entitled to apply for.
My lord, because Lordship will kindly appreciate the facts here. What they have done, my lord. I was arrested and I was suspended. Suspension was not reviewed. I approached this honorable court by filing a writ petition challenging the suspension. Pending, after receiving notice of that writ petition, my lord, they have come up with this shortcut of termination during probation. I served in Bhattadev University, my lord, nearly 3-4 months, my lord. Within 3-4 months, they have reviewed my service during probation period, wherein my appointment order, as well as the, my lord, Bhattadev University, my lord, statutes, it provides that he will be probation period for 1 year. Thereafter, you will have to consider him or make assessment whether he'll continue for 5 years or not. But within 3 months, my service during probation period was assessed, which I have stated in my petition. It's a premature thing. You could not have done.
According to you,
Arrest.
prior to completion of 1 year, There cannot be an assessment.
It's their, my lord, their bylaws also say that, my lord. Because if you are employing a person, you have to give him a reasonable period that yes, then only you will assess his performance. You cannot prematurely assess his performance within 3 months.
But if they are unsatisfied with your service, are they required to suffer for 1 year before they can take a call? Assuming, hypothetically,
Yes.
hypothetically, in a given situation, they find that you are not suitable for the job, or according to them.
Yes.
So are they required to wait for 1 year to
My lord,
make that assessment?
in my humble submission, my lord, you have to give him a, my lord, 3 months is nothing. You have to give him a reasonable period. That is why this 1 year has been prescribed by the statutes also. That at least you have to give him, he is a new entrant, at least give him 1 year, consider his service. If there is something wrong during probation period, you can get rid of him. But here, my lord, previously also, my lord, I placed the minutes or recommendation of the VC. There are, my lord, series of allegation of misconduct against the petitioner. So it's absolutely punitive, my lord. So the FIR, if your lordship will find page 37, I joined, my lord, that this date will be important, my lord. I joined as registrar on 6/5/2022.
Yes.
I joined as registrar on 6/5/2022. On 6/8/2022, the FIR was registered. That your lordship will find page 37. Then, my lord, I was placed under suspension by order dated page 44, my lord, 9/8/2022. So from 6/5 to 6/8, I served in Bhattade. 3 months.
Yes.
So page 44 is the suspension order, my lord.
Yes.
Whereas a case against Sri so-and-so has been registered in ACB police station so-and-so under Prevention of Corruption Act 1988, which is under investigation. And the said so-and-so was detained in custody so-and-so by the Director of Vigilance and Anti-Corruption Assam. And he has remained in custody for a period exceeding 48 hours. Now, therefore, the said Professor so-and-so is hereby suspended with effect from the date of detention, 6/8/2022, in terms of Rule 6(2). Then on in the next page 27/10/2022 is with regard to payment of subsistence allowance. Then page 47, I submitted an appeal for withdrawal of the suspension.
Yes.
Then I filed a writ petition, that is WBC number 7595/2022, page 48.
1 minute.
It's an order copy, my lord,
1 minute.
wherein notice was issued. This is challenging the suspension, my lord. After receiving the copies of the writ petition, my lord, they have come up with this order.
What happened to the earlier writ petition?
Well, that is pending, my lord.
That is still pending.
Yes, my lord, because in the meantime, they have issued this termination
It has
order.
become infructuous, technically.
Yes, my lord, in a sense so, because since if your lordships decide this issue, my lord, that issue already covered.
No, that is challenging the suspension.
Suspension, my lord.
But during pendency, the DP has already started. They have already initiated.
No DP, my lord.
Then?
He was terminated.
Without notice.
Anything, yes, without notice, without inquiry. After receiving the copy of the order in the writ petition, my lord, notice issuing order, they have come up with this order, page 51.
Okay.
As per resolution number so and so of the Executive Council of Bhattadev University, and in exercise of power under section 4.2.2.3 and 4.2.3.2 of the first statute, Dr. So and so is hereby relieved from the service of the said university with immediate effect from 1/2/2023.
Yeah.
My senior has come, he can.
You complete your
Okay, fine.
refreshing
Yes,
our
yes.
memories so that we can.
I am obliged, my lord. I am obliged. So they rely on these two provision, my lord, 4.2.2.3, read with 4.2.3.2 of the first statute. Now, if your lordships kindly take the first statute,
Yes.
my lord, I gave a copy.
Statute.
Statute, my lord.
We also gave a book like this, man.
It's notification dated 20 July 2020.
Yes. Yes.
Lordship will kindly come to page 1792, left-hand side top, my lord.
Yes.
Term of office, my lord. 4.2.2 is the term of office.
Yes.
The registrar shall be a whole-time officer of the university who shall be appointed for a term of 5 years from the date of assuming his office. The term is 5 years. The registrar may resign from the position of registrar by serving advance notice 3 months to the vice chancellor. Now this 4.2.2.3. The executive council may relieve the registrar from the post on recommendation of the vice chancellor. VC has to recommend on sufficient and convincing grounds. So it's not only sufficient, it's sufficient and convincing grounds relating to dereliction of his assigned duties, gross act of delinquency affecting the administration and functioning of the university, violation of established rules, procedures of the university, proven act of corruption, financial, administrative, and moral. So, Lordship will kindly appreciate that all these reasons are directed towards the misconduct. And these grounds, the VC has to derive sufficient and convincing grounds.
Yes.
Now, 4.2.3 conditions of service. What they are trying to say is that since the power of review of probation is there, so they can terminate it, my lord. 4.2.3.1, the registrar shall be a whole-time officer of the university to be appointed for a term of 5 years following the provision and procedure in the Act, Statutes, and Ordinance. Then 4.2.3.2, the registrar shall serve a probation period of 1 year, which may be further extended to another year, after which, on review of her performance during the probation period by the vice chancellor, he shall be confirmed in the position for remaining period of the term. So it says the registrar shall serve a probation period of 1 year. So he shall serve a probation period of 1 year. You need to give him 1 year time to settle down, to understand the nitty-gritties in the university, which may be further extended to another 1 year. So it can be further extended to another 1 year, after which, on review of his performance during the probation period by the Vice Chancellor, he shall be confirmed in the position for the remaining period of term. So his confirmation,
Yes.
it doesn't say that you can relieve him. It say whether he will continue for further or he'll confirmed or not, that will be decided. And it is under the heading condition of service. If you want to get rid of a registrar, the main provision is 4.2.2.3.
Okay. Yes.
Now, Lordships, I place the assessment done by the VC. That assessment of Milord, that is there, Milord, assessment of performance.
Assessment of performance.
Yes, Milord. This was done by the VC, pursuant to which this recommendation, his service was terminated.
What does it say?
Lordship, I just like to read this, Milord. It says basically, Milord, it takes into account the pending criminal case. It contains allegation of insubordination. It contains allegation of financial irregularity, everything, Milord. But they don't want to, Milord, cause an inquiry. They want to get rid of by taking the shortcut. And in their affidavit, their stand is the general unsuitability. He was recharged or terminated for his general unsuitability. Now, Lordship will have to appreciate whether this can at all be considered to be general unsuitability. I can understand general unsuitability, frequently he remain absent from duty or late in coming to his office. Whether this contain, because lifting of veil has already been done, Milord. Records are before your Lordship, Milord. So it says Dr. So-and-so was appointed as registrar of the university-wide order dated so-and-so, and he joined as a registrar on 6/5/2022. As per condition of first statute 4.2.3.2 of the university, which condition is also reflected in the aforesaid appointment order, he was to be taken on probation for a period of 1 year, which was extendable by another year. His further continuance in service was to be decided after review of his probationary service. Unfortunately, Dr. Khataniar was involved in a trap case laid down by the Directorate of Vigilance and Anti-Corruption, Assam. Dr. Khataniar was thereafter caught red-handed for accepting bribe of rupees so-and-so and arrested on the same day itself on 6/8/2022 and remanded to police custody on 7/8/2022. The Directorate of Vigilance and Anti-Corruption, Assam, has submitted a report dated so-and-so to the office of the undersigned, which has been perused. Lordship will kindly mark this. Which has been perused along with certified copy of the FIR, culminating in ACBP's case number so-and-so. The factum, Milord, this assessment is very, very, very crucial thing, Milord. The factum that this arrest and report submitted by the police officer form part of the assessment is sufficient to interfere with the termination order, Milord. By no stretch of imagination, Milord, reliance, which has been perused, he themselves says, it was perused, taken into consideration in taking decision. So absolutely punitive.
Where is the report? Is it available on record?
This is the police report. Police report, Milord, it's not available. Maybe in their record, it may be available, Milord. His arrest was also in mysterious circumstances, Milord. He was taken, he was apprehended in the road, and thereafter, instead of taking him to police station, he was taken to a quarter of Milord Assam Engineering Institute, wherein he was interrogated. So I'm not going into all those things, Milord. That's not required. Then I'll take your lordship to the later part. It is to be noted that the post of registrar is a highly sensitive and key administrative post, which is reposed with extreme trust and maintenance of an impeccable, trustworthy, and clean image in the public arena. Responsibilities of the post include being custodian of official record, etc., officer in charge to issue and receipt of all official communications, to represent the university in the court of law in suit or proceedings by or against the university, sign power of attorney, verify pleadings, official signatory in all memorandum of understanding, memorandum of agreement, or any agreement of mutual cooperation between the university and other institutions, organizations responsible for creating and maintenance of the comprehensive digital database of the university, responsible for coordinating with the finance officer and the vice chancellor for the preparation of budget, statements of accounts, university balance sheet, annual report of the university, conduct of the internal audit, and annual audit of the accounts of the university. And the registrar is also responsible for coordinating with all the concerned officers for regular and timely conduct and academic and administrative audit, etc. So these are the works of the registrar. Now in the next page, my lord. Be that as it may, during the period of 3 months of probationary service, so within 3 months they took decision, since I was arrested, so his probation has to be reviewed within 3 months, my lord. We will not wait for 1 year. Redressed by Dr. So-and-so, it is observed that the performance as well as general activities of so-and-so as registrar so-and-so was largely unsatisfactory, as indicated by the following instances among many others that may be listed. Number 1, Dr. So-and-so would often abstain from his duty as registrar, Bhattacharya University without leave, prior permission. In one such instance, he did not submit an application for admissible leave, even when the undersigned directed him to do so via email. So this is contains allegation of insubordination. On several working days, so-and-so entered the office chamber of the vice chancellor early in the afternoon to tell the undersigned that he would like to leave office for official reasons, leaving the administration to be run by the vice chancellor and others, and even though sometimes permission was not granted to leave office early, he did so. Again, the details are not given on which date, when, nothing, absolutely vague. Allegation of insubordination. While for external activities of the university, the registrar needs prior approval of the vice chancellor, Dr. So-and-so attended a meeting held in Tihu area for which approval was neither sought nor secured. Again, insubordination. The complainant so-and-so oversaw the chairman of auction committee, the auctioning a substantial amount of scrap iron material, and by keeping the vice chancellor in dark, deposited the sale proceeds cash collected into a bank account of the university of his choice. When reminded of the lack of transparency, he argued that he thought the head assistant had or would inform the vice chancellor of the auction process and obligor regarding fund generated through auctioning. It again says that I deposited sale proceeds of the university of my choice account. Lack of transparency, the words used.
How many accounts does the university have?
Milord, that information I don't have, Milord.
All
Whatever be, but I am on the substance, Milord.
All right.
In yet another instance, Milord, I'll go down, Lordship will find more, Milord. In yet another instance of financial irregularity, Lordship will mark this specific allegation that I was involved in financial irregularity. Dr. So-and-so of his own reinvested the maturity value of or the originally invested amount of rupees 50 lakhs without taking approval of the vice chancellor, thus leaving room for audit objection in future.
Now, these, according to you, are not grounds of misconduct.
Yes,
or
these are grounds of misconduct, Milord. These are insubordination, Milord, financial irregularity. If you say in your recommendation, these are grounds of misconduct. If that be so, Milord, then you have to go for an inquiry. How you can terminate, Milord, without
because you are on probation.
No, Milord. Even then, if it's punitive, If it's punitive, if it involves the conduct.
Show us the law.
Yes,
that
Milord.
you're
I'll just,
relying on.
Milord, may I just finish it? 2, 3
Yes.
more. Then para 6, they say that I did not submit the mandatory medical fitness certificate after joining. This is a blatant lie that I can prove because I have annexed the medical certificate, Milord. So this is absolutely false. 7, the lack of responsibility displayed by Sri so-and-so also came into foray when he refused to write his 2 diaries mentioning kilometers traversed by him on official duty and also the days on which he took the official trip for which he needed to spend for the purchase of diesel fuel to run the vehicle used by him. He refused to draw advances to be made available by the university for the purchase of fuel for the official vehicle and instead submitted a series of dubious looking cash memos mostly collected from counters of the fuel pumps instead of electronic receipts that could be obtained directly from the pumps. Some of the receipts and patterns of the expenditure indeed look absurd and reimbursement against such bills are extremely hard to meet. Then para 8, assessing something. So-and-so refused to share vehicle purchase as pool car with others, including controller of examination in connection with some of his works of confidential nature. Even on the instruction of Vice Chancellor, on the other hand, it was reported that frequently he left the official vehicle at his Guwahati residence, so-and-so, while attending office at Patchala, by undertaking his trip in shared private vehicles with some staff members of Waterdeep University. The complainant unduly pressurized the Vice Chancellor to include him in examination advisory committee and also statutory tender committee in which registrar isn't usually a member of obvious reasons. During the 3 months long tenure, Milord, they say it's a long tenure of 3 months. As registrar, it was practically impossible to ensure progress of any work leading to the transformation and growth of the fledgling university due primarily to the lack of acumen or intent on the part of the registrar. For instance, Waterdeep University and for that matter another university follows a practice of calling for price quotes of various items, and once a given rate is approved by the tender committee for which the finance officer, in our case it was the OSD finance during the tenure of so-and-so, is the convener. It is the registrar who would prepare to submit a supply order based on approved rates. It has come to the knowledge of the undersigned that Sri so-and-so would ask OSD finance to take necessary action by refusing to take the due responsibility and in the process unduly delaying the work of the affected early. Then the petitioner was blamed for flood also at serial number 13.
He was blamed for what?
For flood, Milord. Serial number 13, in between 5th line, the undersigned has also directed to write a letter to the state government's water resource department to evaluate the condition of the Pohumara river embankment near Medikusi village, where a plot of land was allotted for the construction of the new campus of the university. Sri so-and-so did not pay heed to any of above directives of the Vice Chancellor. And in the last case, which was to prove rather prophetic in due course, there was indeed a breach of embankment by the raging waters of Pohumara, causing devastation of the village. Literally, the river flew through the new campus land of the university. These are definitely some clear instances of dereliction of duty on the part of so-and-so as registrar. They themselves use this word dereliction of duty. So after recording all these punitive instances, allegations of financial irregularity, they tried to cover up something in the second last paragraph. They have used this word that general unsuitability, Milord. So these are general unsuitability. I'll take your lordships to the law holding the field.
What about the minutes?
Yes, sir. I'm sorry, Milord. I just forgot. I'm sorry. The minutes I placed, and my argument is with regard to the minute. Lordship will kindly come see agenda item number 18. agenda item number 18, Lordship's got. Yes. Regarding the court case filed by Sri so-and-so suspended registrar, one more thing, below this minutes is dated 25/1/2023, 11:30 AM. This is the minutes of the EC meeting. The
25/1.
25/1/2023. I'll show Mirad an interesting aspect here, how they have taken the decision in hot haste, how Milad within seconds their decision Milad changed. The registrar IC informed the House about the court case filed by Sri so-and-so suspended registrar against the university seeking reinstatement to the post of registrar. It was brought to the notice of the House that the Executive Council in its meeting held on so-and-so resolved to continue with the suspension of so-and-so until the conclusion of the legal and departmental proceeding regarding the issue of in pursuance to the letter received from Sri so-and-so on 8/11/2022. The House, after prolonged discussion, decided to stick to its earlier decision taken on this matter and directed the registrar IC to consult the Standing Council for follow-up in the matter. Now, resolution. The Executive Council unanimously resolved to direct the registrar IC to proceed legally in consultation with the Standing Council against the court case filed by Sri so-and-so. So, decision, agenda was what to do and to consult the Standing Council. Therefore, agenda item number 9.
Agenda item number
19, sorry, Milord. Suitability assessment. On the same meeting, Milord. Previous 18 and this 19. The House was of the view that the presence of the regular registrar is essential for the effective functioning of the university. Thus, it has a threadbare discussion to consider if so-and-so, who is presently under suspension in view of the arrest on so-and-so, should continue in the said post of registrar of the university. During the course of the discussion, the House was apprised that so-and-so joined the registrar on probation, but is still holding the lien on so-and-so. Further, the House has been apprised by the Vice Chancellor about his own assessment of performance of Sri so-and-so as probationer from 6/5 to 5/8/2022. Several instances which occurred during the said tenure have been brought to the notice of the House, wherein the Honorable Vice Chancellor had to intervene regarding the actions of Sri so-and-so during this 3-month service period and the probation to ensure smooth functioning of the administrative mechanism of the university. Details of several instances in which the then registrar's action were found inappropriate were presented, read out to the House in the form of various office notes. Words used inappropriate. The House was further informed about instances of, Lordship will mark this, irregularities in financial matters on the part of the said registrar, which are evident in the official notes of the Honorable Vice Chancellor, aimed at making Sri so-and-so to discharge his duties properly. The House noticed the administrative lapse of Sri so-and-so as registrar, which delayed important matters which needed to be taken care of promptly in the interest of the university, which is at its nascent stage. All these factors, circumstances led the House to the unanimously conclude that Sri so-and-so's performance during the probation period was not satisfactory, and as such, he is not suitable to continue as registrar of the university. The House discussed the provisions of the statutes with a view to dealing with the situation in the larger interest of the institution. Now, this is important, Milord. In this regard, the House was apprised by the legal opinion received from the Standing Council of the University on the feasibility of relieving Sri so-and-so from the said post during his probation period. The House went through the legal opinion of the so-and-so and read and deliberated upon provisions under so-and-so of the first statute in detail. And upon much deliberation, decided to relieve Sri so-and-so from the post of registrar Bhattacharya University with immediate effect in the interest of the university. The House also had a threadbare discussion on the matter of advertising the post of so-and-so, keeping in view the need of the permanent registrar to take care of the administrative matters of the university. However, suggested to take opinion from the Standing Council of the university. Now the resolution. That is, Milord, incorporated in verbatim in the impugn order, Milord. The Executive Council so-and-so resolved to relieve Sri so-and-so from the post of registrar from so and so as per provisions under 4.2.2.3 and 4.2.3.2 of the first schedule. So on agenda item number 18, the decision was directed the registrar IC to consult the standing counsel for the following up of the matter in the court in the same meeting below. In agenda item number 19, it was changed.
No, sorry, you're referring
And
to?
my referring, Milord, in agenda item number 18, what was the decision? The House, after prolonged discussion, decided to stick with earlier decision taken in the matter and directed the registrar IC to consult the standing counsel for following up the matter in the court. This is the agenda. Then resolution taken. The Executive Council unanimously resolved to direct the registrar IC to proceed legally in consultation with the standing counsel against the court case filed by Sri so and so. So this was the resolution that we'll have to consult the standing counsel. In the same meeting, this agenda item number 19 was incorporated. I'll prove that, my lord. I'll take your lordship to the affidavit that it was incorporated in the same meeting. And because there was never a process to assess the suitability. It was incorporated in the meantime, and this agenda.
What do you mean by incorporated?
Milord, in the original agenda, that is agenda, Milord, that is which was the agenda which was circulated for the meeting dated 25/1/2023. This agenda of suitability assessment of the petitioner was not there. Because this 18 and 19, it's contradictory, Milord. Because 18, it was resolved in the agenda item number 18, it was resolved that the registrar IC will consult the standing council of the university for further course of action in the matter. Now, he'll have to take, Milord, opinion. Maybe this agenda 19 may be incorporated in the next meeting of the EC. But how can on the same meeting?
Yes.
How can on the same meeting he'll have the instructions, the legal opinion, and take a decision that let us terminate him from service under 4.2.3 and 4.2.3.2.
You are saying that agenda 19 was not there earlier.
Not there. It was not there.
But when the resolutions came, it was found to be there. Is that your submission?
What they did, Milord, when this agenda was, because process is that the agenda is circulated among the members, Milord, Executive Council. In 20, I'll just take your lordship to the affidavit. That will clarify your lordship's query, Milord.
No, we will clarify, but tell us what is your submission?
My submission is that, Milord, in meeting dated 25/1/2023 of the Executive Council.
This was not discussed.
Initially, there was no agenda that his suitability will be assessed. The agenda and the resolution was that the registrar IC will get legal opinion from
It can be an agenda with the permission of the chair, a new additional agenda.
Milord.
Agenda items are circulated.
Agenda items are circulated, yes.
To decide, to apprise the members as to what would be the realm of the discussion. While the matter is going on, normally, you find that with the permission of the chair, some additional items can always be discussed.
Yes.
This is one. Or are you submitting that this item was never discussed and it somehow found its way into the resolution? Which is a very serious allegation.
No, Milord. My submission is that on 24th, they sent email to the members of the EC. This agenda to assess the suitability of the petitioner was not there.
Do you have the copy of the agenda?
Next in our affidavit.
In their affidavit.
That's why, Milord, my subject to satisfaction of your lordship, Milord, my submission is that there is contradiction in agenda items 18 and 19. Decision, resolution.
No, that is what we were trying to understand.
Yes, my lord.
Is your submission restricted to the fact that agenda 18 and 19 are contradicted? Or are you trying to submit something more?
No, what I am trying to submit before your lordship is that, my lord, this process with regard to, my lord, what will be the decision with regard to the case of the petitioner was placed before the EC. That agenda was there, but the agenda that will get rid of him by invoking 4.2.2.3, that came abruptly. Hasty decision. That's what I'm trying to place before your lordship.
All decisions are hasty decisions.
It was absolutely undue haste, because normally agenda are to be circulated within 1 week prior to the holding of the EC meeting, as per the act. If your lordships kindly, I'll just place below the affidavit. Lordship,
Yes.
kindly take the reply of 1, 2, and 3 against the additional affidavit, my lord. Respondent number 1, 2, and 3.
Affidavit dated 11/5/22.
Oh.
Affidavit of
11 addition reply affidavit dated 11/5/2020.
Lord, running page 204 has been shown, my lord. I'm not very sure.
reply affidavit, 12 May.
Yes, once.
It was filed by Subodh.
Yes, correct.
Subodh Chandra Das.
Yes, correct.
Yes.
My lord will kindly come to page 213. This is my, my lord, another limb of argument. This what I found this infirmity, my lord.
So that is what we are trying to understand.
Yes,
What is that
yes.
infirmity?
Yes. Perhaps I'll be able to convey, my lord, by referring to this page, my lord.
Yes.
Page 213.
Hmm.
This was an email dated 24 January 2023.
Hmm.
Now this email contained the agenda at page 215.
215. Yes.
This agenda was for 8th Executive Council meeting,
Hmm.
scheduled to be held on 25/1/2023. Lordship will kindly come to serial number 19 of page 215.
Yes.
215 serial number 19. The agenda was discussion regarding action to be taken against the so-and-so suspended registrar. So this agenda is relatable to email dated 24/1/2023 at page 213.
Hmm.
Which, because attachment shows agenda of the 8th EC meeting was attached with this email.
Hmm.
Now in page 213, there is another email 25/1/2023. Sir, madam, I am sharing the revised agenda for 8th EC meeting for your kind perusal.
Hmm.
Lordship,
Yes.
so on 25/1, revised agenda was published
Hmm.
on the day of the meeting, and page 216 is the revised agenda, wherein this suitability assessment thing was incorporated in serial number 19.
So, yes.
Serial number 19 in page 216, which agenda, this is revised agenda. Milord, brought in on the day of the meeting. Suitability assessment of Sri so-and-so registrar under suspension during the period of probation.
Yes.
So 24 agenda, it was not there. On the day of the meeting, an email was sent to all the stakeholders. 25/1/2023, 11:46 the time the email was sent. And this agenda was incorporated. As per the Act, Milord, the agenda to be circulated 1 week.
Yes.
So this decision, which I'm just trying to convey from the very beginning, that it was taken as a shortcut measure to get rid of the petitioner, to terminate him by invoking 4.2.2.3. This is that my contention is substantiated from here. There was never a decision that they will make the suitability assessment.
Yes.
This is the Act, Milord. Lordship will kindly come to 2.3, the page number 1822.
Act. Statutes.
Sorry, Milord. Regulations, Milord. I'm sorry. First regulation.
First regulations.
Yes. Page number, my lord, top left hand side, 1822. It comes with a heading, meeting of the Executive Council. I have just given, my lord, a copy.
This one. Okay.
Yes, my lord. I'm sorry.
Why don't you give us a complete set instead?
Yes, I can give it, my lord. I
Give
can
it a complete set
I'll just check.
instead of piecemeal.
Yes, my lord.
1822.
1822 page number.
1822. Which heading?
2.3, meeting of the Executive Council.
Yes.
The meeting of the Executive Council may be convened as frequently as it found to be necessary by the Vice Chancellor, but it must meet at least thrice a year. 2.3.2. This is important. A notice of at least.
Yes.
A notice of at least about a week should be given for a meeting of the Executive Council. A week's notice is required for the meeting of the Executive Council. Now they may say so, that yes, notice was given on 24 and subsequent notice in 25. Where is the Milord contention that agenda has to be given along with that notice? They may raise an argument, but if the agenda is not circulated along with the notice, then it becomes a futile exercise, Milord. What you are going to discuss?
No, so therefore we are asking you repeatedly.
Yes, Milord. I'm sorry.
You have to allege mala fide that this was already doctored or prepared to be placed before the committee by XYZ. There was no real-time discussion by the EC or there was no opportunity given to the EC to decide whether the termination of the petitioner is required on these documents. This is your argument in short, that this agenda subsequently came and the decision was taken in undue haste.
That is my submission. Undue haste submission is there, but I will not say, or it's not my submission that this recommendation of the VC was not there at all. It was there. He recommended on 24th. His recommendation date is on 24th.
Your submission is this recommendation is there, but the EC perhaps did not get sufficient time to properly discuss this issue.
True.
You have not submitted that in clear terms.
I'm sorry. I'm sorry.
Either you submit or you don't submit.
No,
we have to record
that
something.
is precisely my thing, Milord, because Act says that one week's notice has to be
But
there.
who is complaining? Who is complaining that this 1 week time has not been complied with by any member? No.
No, the petitioner. The petitioner
Has
is
he been served with a copy of the EC agenda? Was he a part of the EC?
Petitioner, Milord. No.
No.
He
So he was never a part of that.
He was never a part.
So you are
My submission is
you're bringing an allegation of malice, that violating the statutes and the regulations, the EC went ahead to rely on this. That is your submission.
there was undue haste. That is my yes. Correct, Milord. That is my.
Yes.
Then, Milord, I placed the law holding the field on the last occasion. 2005 SCC 152, that was one judgment, Milord. Milord, perhaps on the last occasion, I marked the paragraphs to your lordship's relevant paragraph.
What was the name?
This is my lord Chandra Prakash Shahi versus State of UP and others.
Yes. 2000, volume 5.
Volume 5 SCC 152.
Yes. For what proposition?
Milord, the proposition is that, Milord, motive and foundation, Milord.
What foundation?
Motive and foundation, Milord.
Motive and foundation.
Yes. Whether punitive or not. Para, Milord, I am relying on 21, 22, 23, 24, 26, and 28. Main is 24, 26, 28. But Lordship would also like to go through para 21, 22, 23.
Yes.
Para 21.
Yes.
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 In Gujarat Steel Tubes Limited versus Gujarat Steel Tubes Mazdoor Sabha, it was laid down that a court or tribunal is entitled to find out the true nature of the termination order, namely whether it is punitive or not. In this regard, the form of the order will not be decisive, and the court can give the veil to see the true nature of the order. The court observed that the substance, not semblance, governs the decision. The court further observed that what was decisive was the plain reason for the discharge and not the strategy of a non-inquiry. If the basis was not the misconduct, the order could be saved. The court further observed that the mere fact that after being satisfied of the guilt of the government abandons the inquiry and proceeds to terminate the services of its services by a simple order would not be in the relevant factor in considering the true nature of the order. Given an allegation of misconduct and a live nexus between it and the termination of service, the conclusion would be dismissal, even if full benefits as on simple termination are given and non-injurious terminology is used. Now, para 24, my lord. In Ravindra Kumar Mishra versus UP State Handloom Corporation Limited, it was held that for finding out the effect of an order of termination, the concept of motive and foundation has to be kept in mind. It was further observed that no straight-jacket test can be laid down to distinguish the two, namely the motive and the foundation. Whether motive has become the foundation has to be decided by the court with reference to the facts of the given case. It was also observed that motive and foundation are certainly 2 points of one line, ordinarily apart, but when they come together, motive get transformed and merged into foundation. It was also observed that since in regard to a temporary employee or an officiating employee, an assessment of the service is necessary, merely because the authority proceeds to make an assessment and records its views, it would not be available to be utilized to make the order termination following such assessment punitive in character. It was observed by this court that in the relationship of master and servant, there is a moral obligation to act fairly. There should be an assessment of the work of the employee, and if any defect is noted in his working, the employee should be made aware of the deficit in his working and deficiency in his performance. This was never done with the petitioner. Defects or deficiency, indifference or indiscretion may be with the employee by inadvertence and not by incapacity to work. Timely communication of the assessment of work in such cases may put the employee on the right track. Without any such communication, it was observed it would be arbitrary to give a movement order to the employee on the ground of unsuitability. Now, para 26. In Radhesham Gupta versus UP State Agro Industries Corporation Limited, which related to a probationer, the whole legal position was reviewed by the brother M. Jagannath Rao J. in an illuminating and research-oriented judgment. And after considering various decisions, including the decision in Kushal Kishore Shukla case and a still later decision in so-and-so, so as to trace the development of law relating to this aspect of service jurisprudence, laid down that there has not been any conflict of opinion. Inter se various judgments, including those laying down the motive and foundation theory. It was held that the question whether the order by which services were terminated was innocuous or punitive in nature had to be decided on the facts of each case after considering the relevant facts in the light of the surrounding circumstances. The benefit and protection of Article 311(2) of the Constitution is available not only to temporary employee, but also to a probationer, and the court in appropriate case would be justified in lifting the veil to find out the true nature of the order by which the services were terminated. Now, para 28, my lord.
What is the status of the criminal proceedings?
My lord, nothing has been proceeded. No charge sheet has been filed as of now.
Have you filed any quashing petitions?
No.
Again? Okay.
He is already, my lord, in a lot of trouble, my lord.
Yes, please carry on.
Para 28. The important principles.
Well, only one information, the police or the prosecution sought the sanction which you have given. Vigilance department.
Para 28. The important principles which are deducible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post in question. If for the determination of suitability of the probationer for the post in question or for his further retention in service or for confirmation, an inquiry is held and it is on the basis of the inquiry a decision is taken to terminate the service, the order will not be punitive in nature. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct and an order terminating the service is passed on the basis of that inquiry, the order will be punitive in nature as the inquiry held not for assessing the general suitability of the employee for the post in question, but to find out the truth of the allegations of misconduct against that employee. In this situation, the order would be founded on misconduct. It would not be a mere matter of motive. 29. Motive is the moving power which impels action for a definite result. Or to put it differently, motive is that which incites or stimulates a person to do an act. An order terminating the service of an employee in an act done by the employer. What is the factor which impelled the employer to take this action? If it was the factor of general unsuitability of the employee for the post held by him, the action would be upheld in law. If, however, there were allegations of serious misconduct against the employee and a preliminary inquiry is held behind his back to ascertain the truth of those allegations and a termination order is passed thereafter, the order having regard to other circumstances would be founded on allegation of misconduct which were found to be true in the preliminary inquiry. Now, Lordship will come to the
So in the context of your case, how do you rely on this?
My submission is that, my lord, Lordship has seen the assessment. Firstly, my lord, in para 28, sorry, my lord, in para 24, in the case of Ravindra Kumar versus Mishra versus UP State Handloom Corporation, the Honorable Apex Court has held that, yes, an employee may not be up to the mark. There may be lacunas in his service. So if there is any lacuna in his service or if he is not up to the mark, then your attempt should not be to discontinue or disengage or terminate his service. You are to give him opportunity. Look, Mr. So-and-so, this act or this work is not as per the requirement. So that opportunity has to be there. No such opportunity was ever given to me. The serial number 1 to Milord,
You had worked as a registrar earlier. You are expected to know what a registrar is.
Fine, my lord. If there was any lacuna in my service, if I was not beyond your expectation, or I was lacking in some work, that the lackings that the VC in his recommendation has narrated, the requirement of law is that the petitioner should have been given to improve upon those lackings. There is another judgment next, which has been, this aspect has been elaborated in judgment. I'll take. So, firstly, that was never done. Secondly, my lord, the Honorable Apex Court has said or held that you have to, the court has the power to lift the veil and go to the originality of the decision. If the originality of the decision contains allegation of misconduct,
yes,
then it becomes the foundation. It's not mere motive of general unsuitability. Here in our case, my lord, Lordships, I have referred, I have already taken your Lordships to the recommendation of the VC, which contains allegation of financial irregularity, insubordination, which are all misconduct. And 4.2.3, it says sufficient and convincing reasons. It doesn't say only sufficient. So inquiry is a must in that background. which they failed to do. And they took this shortcut after the filing of the writ petition challenging suspension. Agenda item number 19 was incorporated. No, let get rid of him. And mere reference of the VC by the VC of the criminal pending criminal case and marking a remark that I have perused the same is sufficient to come to a conclusion, in my humble submission, that the background is the criminal case as well as the misconduct, not general unsuitability of service. Next judgment, I am trying to, I'll just place.
Is the pendency of the criminal case, can it not be considered to be ground of unsuitability?
Lord, it is, Lord, still the criminal case is under trial, my lord.
No, but ordinarily, if you are regularly appointed,
yes,
you would have been placed under
then,
suspension.
then there should have been an inquiry held. He is entitled to place his say into the matter, my lord.
All right.
My lord, this is a thing that without any notice, anything, my lord, you have terminated. So yes, if my service was unsatisfactory for general unsuitability,
What is general unsuitability? How do you define general unsuitability?
My definition, or one instance or two instance, I can find that if I am not regular in service, or if I come to the work late. These are only two examples, my lord. There may be many examples of general unsuitability, but an assessment which is not based on allegation of misconduct. If the assessment would not have been based on misconduct, if the insubordination thing would not have had not been there, or allegation of financial irregularity would not have been there, perhaps the VC maybe he may justify his reason. But on the face of those which has come before your lordships after lifting of bail, or from the original decision making process or recommendation, in my humble submission, it's absolutely punitive.
Yes.
Then, my lord, next judgment I am relying on is Anup Jaiswal, 1984 2 SCC 369. But I gave copy of this.
Yes.
1984 to SCC 369. I'm relying on Milo 10, 11, 12, 13, and 16.
1 minute, please. Anup Jaiswal.
Yes, Milo.
Okay.
10, 11, 12, 13, and 15, Milo.
Yes. Yes. This is for what proposition?
This is for the proposition that you need to give him opportunity to place or to improve upon his shortcomings, my lord. You cannot throw away.
Yes. Paragraph?
Paragraph 10, 11, 12, 13.
Yes.
I'll take your lordships with 11, my lord. On behalf of the Union of India, reliance has been placed on state of Punjab versus so and so, so and so, so and so. We have gone through these decisions, except the case of so and so. All other cases referred to above were decided prior to the decision in Samsher Singh's case, which is a judgment delivered by a bench of 7 judges. As pointed out by us in all these cases, including the case of Ramchandra Trivedi, the principle applied is the one enunciated by Purushottam Lal Dhingra case, which we have referred to earlier. It is urged, relying upon the observation of the Sukhraj Bahadur case, that it is only Article 311(2) of the Constitution, i.e., then enquiry officer is appointed, a charge submitted, explanation called for and considered, and any termination made thereafter will attract the operation of Article 311(2). It is significant that in the very same decision, it was stated that the circumstances preceding or attendant on the order of termination of service have to be examined in each case, the motive behind it being immaterial. As observed by Ray CJ in Samsher Singh's case, the form of the order is not decisive as to whether the order is by way of punishment, and that even an innocuously worded order of terminating the service may, in fact, circumstance of the case establish that an inquiry into allegation of serious and grave character of misconduct involving stigma has been made in infraction of the provisions of Article 311(2). It is therefore now well settled that where the form of the order is merely a camouflage for an order of dismissal for misconduct, it is always open to the court before which the order is challenged to go behind the form and ascertain the true character of the order. If the court holds that the order, though in the form is merely a determination of employment, is in reality a cloak for an order of punishment, the court would not be debarred merely because the form of the order in giving effect to the rights conferred by law upon the employee. In the instant case, the period of probation has not yet been over. The impugn order of discharge was passed in the middle of the probation period, likewise in our case. An explanation was called for from the appellant regarding the alleged act of indiscipline, namely arriving late at the gymnasium, acting as one of the ringleaders on the occasion, and his explanation was obtained. Similar explanations were called for from other probationers and inquiries were made behind the back of the appellant. Only the case of the appellant was dealt with severely in the end. The cases of other probationers who were also considered to be ringleaders were not seriously
I think
taken
the facts
note
are
of.
different here.
Milord, I am on the proposition of law.
The
proposition,
proposition of
yes,
law is
that
known
is
to
settled.
all. How this proposition of law you want to apply to your
Yes,
facts of the case would be relevant.
just read Milord down below.
Yes.
Though the noting in the file of the government may be irrelevant, the cause for the order cannot be ignored. The recommendation of the director, which is the basis or foundation for the order, should be read along with the order for the purpose of determining its true character. If on the reading of the two together, the court reaches to the conclusion that the alleged act of misconduct was the cause of the order, and that, but for that incident, it would not have been passed, it is inevitable that the order of discharge should fall on the ground, as the appellant has not been afforded a reasonable opportunity to defend himself as provided in so and so. So, the recommendation of the order, which is the basis here, the recommendation of the VC.
Which is a mandate of your statute only.
Yes, the recommendation of the VC and the order pass had to be read together to come to a conclusion. So here in this case, they did not hold any inquiry. They did not hold any inquiry. They did not give any show cause. So if you want to
see, there is a power.
I'm sorry.
There is a power under the statute that you'll be under provision for 1 or 2 years. And during the provision, the authority is within its rights to decide.
No, it says I'm sorry, Milo, subject to correction, Milo. It says during initially provision for 1 year, then 2 year, after which they will review whether he'll continue for 5 year or not. Sorry, Milord, whether he'll be confirmed or not.
Correct.
It doesn't say that you can get rid of him. The getting rid power is under 4.2.2.3.
Correct. So
Yes.
that is on the basis of the recommendation of the BC.
Yes. Sufficient convincing ground. It's not only sufficient. How you will be convinced? You have seen the note, you have made your recommendation.
No, are you submitting that this 4.2.3 is only in respect of termination of the registrar?
Yes, my
in
lord.
any other case except for unsuitability during provisional period. Is that your submission?
Yes,
Are
my
you,
lord.
are you
To an extent, yes. You cannot get rid of because if
you
your
cannot
lordship
use 4.2.3 for terminating the
Yes.
services during probation.
Yes, because
And if
it-
you
the-
use 4.2.3, you have to follow the mandate of 311.
because it's condition, it is under 4.2.3.2 is under the heading condition of service. It's not required, it's not written that he can be terminated under that. They say in their affidavit that both are to be harmoniously read. Milord, if we read both these provisions in any manner, the only conclusion that comes is that the VC has to have sufficient and convincing grounds, and grounds were mentioned. Now here also, though the noting in the file of the government may be irrelevant, fine. The cause for the order cannot be ignored. The recommendation of the director, which is the basis or foundation for the order, should be read along with the order for the purpose of determining its true characters. So how will determine the true character of the order? Reading the recommendation along with the order. If on reading of two together, the court reaches the conclusion that the alleged act of misconduct was the cause of the order, and that, but for that incident, it would not have been passed, then it is inevitable that the order of the recharge should be followed on the ground, and the appellant has not been afforded a reasonable opportunity to defend himself as provided in Article 311(2). So reading of the recommendation, which everywhere it contains allegation of insubordination, financial irregularity, along with the order, coupled with the fact that they have also referred the pending criminal case, leads to the conclusion that the misconduct was the only ground because of which the petitioner's service was terminated. Those recommendations given by the Vice Chancellor, in my humble submission, Milord, a bare reading of those leads to the conclusion that the allegation of element of misconduct was there in those points.
Yes.
Then, my lord, next judgment, 2013 3 SCC 607. Proceed, got my lord. State Bank of India versus Palak Modi.
Okay, you read, you give me a printout.
Can I get an extra copy? Lord, I've got an extra copy.
This is 2000.
2013 3 SCC 607.
Yes.
Facts your lordship will find at para 6. The brief issue was in
Yes.
in the counter affidavit filed on behalf of the appellant, it was pleaded that the decision to extend the probation of the private respondent and to terminate their services was taken after considering the report sent by IBPS about suspected use of unfair means by the candidate. So there was suspected use of unfair means, and that was a report was prepared, and thereafter they were terminated. Now, Lordship will kindly come to para 25.
Yes.
Milord, all the judgments previously Milord, delivered by the Honorable Apex Court were relied on in the preceding paragraph. Now, para 25 it provides. The ratio of the above noted judgment is that
Oh, yes.
a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post held by him. If the competent authority holds an inquiry for judging the suitability of the probationer or for his further continuance in service or for confirmation, and such inquiry is the basis for taking decision to terminate his service, then the action of the competent authority cannot be castigated as punitive. However, if the allegation of misconduct constitutes the foundation of the action taken, the ultimate decision taken by the competent authority can be nullified on the ground of violation of rules of natural justice. So if you would have hold an inquiry and come to a conclusion, things would have been different.
Hmm.
Now,
Inquiry for suitability. Inquiry for suitability.
Yes, they say.
Yes.
Then, my lord, para 36.
Yes.
There is a marked distinction between the concept of satisfactory completion of probation and successful passing of the training test held during or at the end of the period of probation, which is sine qua non for the confirmation of a probationer and the bank's right to punish a probationer for any defined misconduct, misbehavior, or misdemeanor. In a given case, the competent authority may, while deciding the issue of suitability of the probationer to be confirmed, ignore the acts of misconduct and terminated his service without casting any aspersion or stigma which may adversely affect his future prospects. But if the misconduct or misdemeanor constitutes the basis of the final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, the court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employee for an act of misconduct. Now, in our case, my lord, they, in their affidavit, say that the petitioner was terminated for general unsuitability. But if your lordship see the termination order, it doesn't say so. Termination order doesn't say that Mr. So-and-so, you are terminated from your service because your service was not satisfactory during probation period. What it does, it referred to 4.2.2.3. The moment you refer to 4.2.2.3, the ingredients mentioned in 4.2.2.3 come. So you cannot improve your case by filing this affidavit. Now, para 37. The use of unfair means in the evaluation test, confirmation test held by the bank certainly constitutes a misconduct. The bank itself has treated such an act to be a misconduct. It is not in dispute that the service of the private respondents were not terminated on the ground that there was any deficiency or shortcoming in their work or performance during probation, or that they had failed to satisfactorily complete the training or had failed to secure the qualifying marks in the test held on so and so. As a matter of fact, the note prepared by the Deputy General Manager, which was approved by the General Manager, makes it crystal clear that the decision to dispense with the service of the private respondent was taken solely on the ground that they were guilty of using unfair means in the test held on so and so. To put it differently, the foundation of the action taken by the General Manager was the acquisition that while appearing in the objective test, the private respondent had resorted to copying. The IBPS had relied upon the analysis made by the computer and sent a report to the bank that 18 candidates were suspected to have used unfair means. The authority concerned then sent for the chart of seating arrangement and treated the same as a piece of evidence for coming to the conclusion that the private respondents had indeed used unfair means in the examination. This exercise was not preceded by an inquiry involving the private respondents, and no opportunity was given to them to defend themselves against the charge of use of unfair means. In other words, they were condemned unheard, which in our considered view was legally impermissible. Then para 39. One of the several grounds on which the appellants in Ajit Singh case challenged the termination of their service was that the action of the employer was wholly arbitrary, discriminatory, and violative of equality clause contained in the Constitution. While passing the orders dated so and so, this court observed, when the master-servant relations was governed by the Arctic law of hire and fire, the concept of probation in service jurisprudence was practically absent. With the advent of security in public service, when termination or removal becomes more or more difficult, or order of termination or removal from service become a subject matter of judicial review, the concept of probation came to acquire a certain connotation. If unless he is given an opportunity to meet the allegations, if any, against him, which necessitates his removal from service, rules of natural justice postulate an inquiry into the allegations and proof thereof. This developing master-servant relationship puts the master on guard in order that an incompetent or inefficient servant is not foisted upon him, because the charge of incompetency or inefficiency is easy to make but difficult to prove. Concept of probation was devised to guard against errors of human judgment in selecting suitable personnel for service. The new recruit was put on test for a period before he is absorbed in service or gets a right to the post. Period of probation gave a sort of lucus poenitae to the employer to observe the work ability, efficiency, sincerity, and competence of the servant. And if he is found not suitable for the post, the master reserves a right to dispense with his service without anything more during or at the end of the period, a prescribed period, which is styled as period of probation. Viewed from this aspect, this is important. The court had held that termination of a probationer during or at the end of the period of probation will not ordinarily and by itself be a punishment, because the servant so appointed has no right to continue to hold such a post any more than a servant employed on probation by a private employer is entitled to. The period of probation therefore furnishes a valuable opportunity to the master to closely observe the work of the probationer, and by the time the period of probation expires, to make up his mind whether to retain the servant by absorbing him in regular service or dispense with his service. Period of probation may vary from post to post or master to master, and it is not obligatory on the master to prescribe a period of limitation. It is always open to the employer to employ a person without putting him on probation. Power to put an employee on probation for watching his performance and the period during which the performance is to be observed is the prerogative of the employer.
Yes.
So once you have prescribed for a period, that will be for probation for a period of 1 year, and thereafter it will be reviewed, your performance will be reviewed, and your further continuance or your tenure of 5 years, fate of your tenure of 5 years will be decided. How can you make this premature assessment within 3 years, 3 months? What a person will do. And within, so this premature assessment made by the Vice Chancellor, in my humble submission, is arbitrary and illegal, because the provisions to 4.2.3.2 says shall. A person shall be in probation for 1 year.
Yes.
So this is absolutely a shortcut to get rid of the petitioner, absolutely punitive, founded on alleged misconduct by the petitioner, and without inquiry, without show cause notice, the termination of service of the petitioner by the impugn order dated 31/1/2023 is absolutely illegal. The petitioner, he deserves reinstated in service with full back wages. And the irony is that his lien is going to be over on 5th of May in the Guwahati University, So he's little apprehensive, about his fate of his entire career.
Okay.
So that is, how I just like to refresh your lordship.
Definitely.
You are relying on only on these two judgments.
Yes. 3 judgments,
Three judgments.
3 judgments.
Chandra Prakash, Anup, and Palak.
And Palak Mut. 2 judgments I have for this. Also, will kindly refer to this for substantiating claim of back wages, Reply to this.
Yes. Okay.
Only for the purpose of claim of back wages.
What are these two judgments?
One is below 2016 SCC 663. And another is 2004 1 SCC 43.
No,
For the proposition that in the event my prayer is allowed, the termination order set aside, he is entitled for back wages. Only for that proposal.
Yes.
The records were already called for, Lordship can have a look at the record. Deeply obliged. Yes. May please, your Lordship. I appeared for the university. 1, 2, and 3. Now, my lord, my learned friend's argument are basically on 2 counts. The first is that the so-called suitability assessment would not have been done without completion of period of 1 year. And secondly, the other basis on which the writ petition has been structured is, here is a case where there is a duty cast upon this honorable court to leave the field and find out that it is basically based on certain allegations of misconduct that the order of termination is found. These are the 2 broad, principles based on which my learned friend is.
Not on unsuitability, but on misconduct.
Yes.
That is
That is on the merits. Now, my lord, let me address on the first point. Now, please have the regulation which my learned friend has placed, my lord.
Please come to 4.2.3.2.
The first regulation.
Yes. My lord, one very important aspect, my lord, an impression is not to be given that with his termination he will be jobless or something. The writ petitioner is a substantive employee of the Guwahati University. He is holding lien over his post. My lord, he joined our university on a tenure post and we found him mount suitable, my lord. Now he has been released. He can go back to Guwahati University and do his job, my lord. That way there is absolutely no problem. No prejudice at all would be caused to the petitioner.
What is the regulation?
Regulation is, my lord, 4.2.3.2 on page 1792. On top, my lord, the gazette copy. My learned friend referred to it, 4.2.2.3 and 4.2.
You're referring to the statutes.
Yes,
statutes.
Is the first statute.
First.
Well, I find it very complicated, my lord. The statutes, rules.
Rules.
We are more familiar with acts and rules, man.
Correct. Correct. Therefore, I had to ensure whether it is the regulations or the statutes. 4.3.2, yes.
Yes. The registrar shall be 4.2.3.2.
Yes.
The registrar shall serve a probation period of 1 year, which may be further extended to another year, after which, on review of his or her performance, during the period of probation, during the probation period by Vice Chancellor, she shall be confirmed in the position for the remaining period of the term. Well, this 4.2.3.2, in my humble understanding, it envisages two exercises. On completion of 1 year period, there could be an assessment whether he requires further extension, or, my lord, during the first period, whether there is any requirement of suitability assessment. So this expression during, which finds place in the second sentence, has to be given a meaning. Lord, we all know about the interpretation of statutes, my lord. Every word in a statute has to be given a meaning. Without, giving a meaning to the expression during, my lord, I don't think it is possible to appreciate the scope of the or purport of this particular clause. In any case, my lord, this aspect of the matter has been well settled by the Supreme Court in Palak Modi's case, that this suitability reassessment could be at the end of the, my lord, period of probation or during the period of probation. So that way, my lord, there is no ambiguity in the legal position. It is rather res integra that it can be done during the period of first 1 year also. Now, Palak Modi judgment, my learned friend has already referred, my lord. I'll just take your lordships to that. Para 25. Citation is, my lord, 2013 3 SCC 607.
Yes.
At page 624, para 25. End of the day, my lord, this concept of motive, foundation, etc., these are all judicially won by different judgment, starting from, my lord, Purushottam Lal Dhitra. Now please come to para 25. The ratio of the above noted judgment is that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of period of probation on account of general unsuitability for the post held by him. It is also a fact that we cannot give a meaning to the expression, my lord, probationer or confirmation in vacuum. It will also depend upon the particular statute or the service order which, my lord, governs the selection. Here 4.2.2.3 makes the position clear that the exercise to find out whether a probationer is suitable to be retained or his period of probation should be further extended, my lord, that depends upon the facts of each. So, my lord, law is well settled now that for the purpose of assessing the suitability, it can be done at the end of the period of probation or during the period. Now, here in the instant case, my lord, not only the statute permits, in fact, it has been done. I'll come to my affidavit when it is done. So, just to steer clear of the first point, my lord, I refer to this particular statute as well as to the decision in Palak Modi for the proposition that it is perfectly permissible for the employer, my lord, to undertake an exercise even during the period of probation. So we need not have to wait till the period comes to an end. Almost 1 o'clock. I can another 5 minutes. I can continue. Yes. My lord, can I place my affidavit just 2 paragraphs?
Or would you be comfortable?
No, it's okay, my lord. I can complete the reading of my affidavit.
Okay.
My affidavit, it starts at, my lord, page 51. 52. Index part 2 Supreme Court
Affidavit or additional affidavit?
Affidavit in opposition. I'll rely upon 2 paragraphs, paragraph 6 and 7. At page 54. Affidavit in opposition filed by respondents number 1, 3, 4, and 5. Dr. Subhas Chandra Das, in charge registrar.
Yes.
Yes. That the statements made in para 34 and 35 of the writ petition being misconceived and baseless, the answering respondents categorically denies the correctness of the same. In this regard, it is humbly stated that protection under Article 10 and 11(2) of the Constitution would be available to a government servant only when his removal from service is relatable to some misconduct. In the case at hand, the petitioner, page number 55, my lord.
Yes, yes.
In the case at hand, the petitioner has not been relieved from service for any misconduct. The competent authority assessed the performance of the petitioner during his probation period and found him to be unsuitable for continuing in the capacity as registrar of the university. As such, the petitioner has been relieved from service by order dated 31/1/23. It is stated that petitioner has neither been released for his involvement in ACBPS case number so-and-so, nor as a punitive measure for his involvement in the said criminal case. Needless to say that petitioner is holding lien in his substantive post of academic registrar in Guwahati University and is free to join the said post. That the statement made in paragraph 36 to 40 of the writ petition being wholly misconceived and baseless, answering deponent categorically denies the correctness of the same. A contention is sought to be advanced by the petitioner as if section 2.3 of first statute can be invoked by the authorities to relieve the incumbent registrar from service only in case of dereliction of assigned duty gross act of delinquency affecting the administration and functioning of the university, violation of the established rules and procedures of the university, and proven acts of corruption, financial, administrative, and moral. Further, it is contended that the aforesaid grounds being relatable to a misconduct on the part of an employee, a departmental inquiry is a sine qua non for removing such employee on such ground. Same having not been done, the impune release order dated is violative of so and so of the Constitution. Same having not been done, the impune release order is so, and that's the contention. In this regard, the answering respondent respectfully begs to state that apart from the aforementioned ground, an incumbent registrar can be released in terms of the grounds enumerated in 4.2.3.2 of the first sentence. This is our case. The said provision stipulates that the vice chancellor of the university can assess the performance of the registrar during his probation period so as to arrive at a satisfaction regarding his further continuance or not. Upon such assessment, the service of the registrar may either be confirmed or he may be relieved from service by the Executive Council on the recommendation of the Vice Chancellor. Hence, the grounds enumerated in section 4.2.3.2 has to be harmoniously read with section 4.2.2.3 of the first statute. Further, it is no longer a sine nigra that an act of releasing provisioner from service on the ground of general unsuitability does not attract the vice of Article 10.11.2 of the Constitution and the laws framed thereunder. Coming to the case in hand, the petitioner admittedly joined as registrar of the Bhattadev University on 6th of May 22 and served in the said capacity till 5/8/22. The petitioner was arrested on 6/8/22 in connection with ACB PS case number so and so, after being caught red-handed while accepting bribe. Accordingly, he was placed under suspension by order dated so and so under Rule 6.2 of the Rules of 64. Be that as it may, a perusal of clause 7 of the petitioner's appointment order dated 25/4/22, along with section 4.2.3.2 of the first two, would reveal that the first year of petitioner's service would be under probation. That being the position, Vice Chancellor assessed the performance of the petitioner during his probation period and thereafter placed his recommendation before the Executive Council in its meeting held on 25/1/23. In the said meeting, Executive Council was also apprised about various instances where a petitioner had failed to render his duties in a desired manner, hampering the interest of the university, which is in its nascent stage and which came into existence by notification dated so and so and started functioning from May 1. Upon much deliberation and considering the materials available on record, the Executive Council resolved to relieve the petitioner from service on account of his general unsuitability to hold the post of registrar by resolution dated so. As such, in terms of the said resolution, impune order has been issued relieving the petitioner from service with effect from 1st of February 23. Therefore, attempt on the part of the petitioner to portray the impune order dated as bad in law by solely relying upon section 4.2.2.3 and ignoring section 4.2.3.2 of the first schedule does not hold water, resultantly warrants rejection at the hands of the Honorable Court. So this is the basic premise, my lord, on which we have structured our case, or rather our case stands, my lord. At 2 o'clock, I'll make my submission.
Date after 10 days, Lordship.
We had fixed the date, therefore, since there was no instruction, we
Yes,
asked
Lordship, but yes, Lordship.
who will take the responsibility of filing?
Lordship, I am taking, Lordship.
All right. At the request of learned counsel appearing for the department, MSM Bhattacharya, additional matters can adjourn for 2 weeks,
Lordship.
enabling her to file the additional
Affidavit, Lordship. FIR was also filed, Lordship, and we need to take the status, updated status.
Please report.
My lord, last occasion also he was not present. Today also he never come, my lord. Actually, he becomes infectious. Honorable court has passed an
All right, we're fixing it on Monday.
My Lordship will pass an order, my lord, on that day, he did not come, my lord.
Courtmaster has been informed that he is out of station.
Corribgon, sir. Otherwise, he will not come, my lord. I'm sure. Because
we are giving him one more opportunity, list on Monday.
Third
Item number
opportunity, my
51. Learned counsel to the petitioner is not present. Is informed that he is out of station. According to matters adjourned. Listed on Monday. Coming
Monday. Obliged.
The courtmaster is permitted to inform counsel for the petition. Mr. Court. Yes.
My lord, before I make my legal submission, my learned friend, just to make out a case of malice, my lord, he referred to that notice where, according to the learned friend, my lord, this suitability aspect was not indicated in the first notice. If your lordship will kindly come to page number 215. Reply filed by us. Reply by the university to the affidavit, additional affidavit filed by the petitioner.
215.
Yes. Agenda of the 8th Executive Council meeting is the heading, my lord.
Agenda.
Yes. Page 218.
Yes.
Now please come to my lord serial number 19.
Yes.
Discussion regarding action to be taken against Guru Prasad Khatonia, suspended register. Then please come to 20. Any other business with the permission from chair. So my lord, in any case, my lord, under that residuary item entry of 20, any matter can be discussed provided, the chair gives the permission. But in any case, at page 216, serial number 19, suitability assessment of Guru Prasad Khatonia under suspension during the period of probation. Now here, my lord, my learned friend was trying to draw lordship's attention to clause 2.3.2 of the statute, my lord, whereby they say that 7 days notice is required. My lord, 7 days notice is regarding, my lord, calling of a meeting, not regarding fixation of agenda. And the notice was issued on 12/1 and meeting was held on, my lord, 25/1. So there is no infraction. In any case, my lord, a procedural law, my lord, has always to be given a meaning so that it subserves in achieving the main objective of the enactment. Procedural law is never to be read in the manner as my learned friend would like your lordship to read it. Otherwise, my lord, there will be a whole lot of difficulty. Administrative convenience, so many other things. Why it is said, my lord, when it comes to review by administrative authority, no power of review is required. Whereas a judicial or a quasi-judicial authority, if they have to exercise power of review, then, my lord, it has to be expressly provided. So procedural law has to be given a meaning. Basic idea is so that it subserves in achieving the main objective. Nothing beyond that, my lord. So therefore, my lord, by referring to this, a case of malice cannot be made. That I have referred to that point. Now let us come to the main gist of the matter. Ideally, perhaps my learned friend would like to argue that though the order is innocuous, it is basically founded on some allegation. That is his purport. Now, therefore, the lordship will have to do some allegation. Now, my lord, the very heading of the discussions goes to show that it was to judge the suitability of the individual. Nothing beyond that matter. There is no scope of any further interpretation. Now, the question is, while judging the suitability, what is the scope? Now, my lord, so far as an probationer is concerned, to judge his suitability, what are the factors that can be taken note? In which situation, my lord, that termination simpliciter will become an order founded on allegation? These are areas which are not, my lord, gray. These are all, my lord, settled areas. I'll rely upon two judgments of the Supreme Court on this point, which will go to establish, demonstrate that it's a pure and simple case of termination simpliciter. It is not founded on any allegation. First, my lord, I'll rely upon that judgment of the Justice Krishna in that Gujarat Steel Tubes case. 1982 SCC 593. This one is 593.
1980.
1980 SCC 593. I'll read para 53 and 54, my lord, where the law has been succinctly laid down by the Honorable Justice, my lord, Krishna.
Yes.
Para 53 and 54. Masters and has a lots of page 617.
You carry on, I'll try to locate the. Yes.
Masters and servants cannot be permitted to play hide and seek with the law of dismissal, and the plain and proper criteria are not to be misdirected by terminological cover-ups or by appeal to psychic process, but must be grounded on the substantive reason for the order, whether disclosed or undisclosed. The court will find out from other proceedings or documents connected with the formal order of termination what the true ground for termination is. If thus scrutinized, the order has a punitive flavor in cause or consequence, it is dismissal. If it falls short of this stage, it cannot be called punishment. To put it slightly differently, a termination effected because master is satisfied of misconduct of the consequently and of the consequent desirability of terminating the services of the delinquent servant is a dismissal, even if had the right in law to terminate with an innocent order under the standing order.
You have an
or
extra
other.
copy, no?
Okay.
You have an extra copy? Huh? Okay, carry on.
I'm sorry, my lord.
1980, volume 2 SCC.
Yes, my lord. 593. Para 5350.
1980, volume 2 SCC.
গোটেইখিনি নহলেও আপুনি এটা কাম কৰক পেজ 593 আৰু 6172 উলিয়াই দিয়ক পেজ 617 618 593 617 618
Okay, please carry.
Yes. To put it slightly differently, a termination effected because master is satisfied of misconduct and of consequent desirability of terminating the service of the delinquent servant is a dismissal, even if he had right in law to terminate with an innocent order under the standing order or otherwise. Whether in such a case grounds are recorded in different proceeding from the formal order does not detract from its nature, nor the fact that after being satisfied of the guilty, master abandons the inquiry and proceeds to terminate. Given an alleged misconduct and a connection between it and the termination of service, the conclusion is dismissal, even if fruitful benefits as on simple termination are given and non-injurious terminology is used. Now, this is important. Para 54. On the contrary, even if there is suspicion of misconduct, the master may say that he does not wish to bother about it and may not go into his guilt, but may feel like not keeping a man he is not happy with. He may not like to investigate nor take the risk of continuing a dubious servant. Then it is not dismissal, but termination simpliciter, if no injurious record of reasons or punitive pecuniary cutback of his full terminal benefit is found. Time on this, my lord. There may be allegation. I, as an employer, is not interested in finding out whether it is right or wrong. At the same time, I'm not interested. I don't think I should keep him. Then it will be still a termination simplicity. So this has been followed in Radhesham Gupta and all subsequent cases. Pale? So, my lord, this is the passage. For, in fact, misconduct is not the moving factor in the discharge. We need not chase other hypothetical situations here. Well, I would like to read this paragraph together, my lord. There's got a lot of.
What are the facts involved in that?
No, facts in this case are, my lord, may be different. Of course, my lord, a decision is an authority for what it actually decides. That's correct. But here, my lord, the Honorable Supreme Court has visualized the situation. When an order will be punitive, when it will be not. Para 53 says when it will be punitive. Para 54 says when the exceptions can be carved. I am on para 54. নাপালে নেকি তা মোক দিয়কচোন মই উলিয়াই দিম পালে
It's not clear. But
কাম কৰকচোন সৰি kindly have a look at para 54, my lord.
yes.
Para 54, my lord. Now, in para 54, Lordship has noticed that it will not be punitive if no, reasons are recorded or by Lord, any punitive aspect is highlighted. Kindly come to page 51 of the impugn order of the writ petition. Page 51.
Yes.
As per resolution of the Executive Council of the Bhattadev University and in exercise of power under so-and-so read with so-and-so of the first statute, Dr. Guru Prasad Khatoniar, Registrar, Probationary is hereby relieved from the services of the said university with immediate effect. He has been relieved. So it does not include any, my lord, anything to, implicate him to any misconduct or in. It is an innocuous order by which he has been relieved. It does not contain anything to suggest that action has been taken based on some allegation. That is the requirement envisaged in para 54, if the order is otherwise not stigmatic.
Yes.
So therefore, my humble submission is, my lord, it's a case where there is no scope to infer that the order of termination is based on any misconduct. Then, my lord, Chandra Prakash Sahi's case, my learned friend has referred. I am also relying on that judgment, my lord. Para 28. Citation is 2005 SCC 152.
Yes. You're relying on paragraph?
28. In fact, I'll rely upon only these two judgments. I'm not relying, sorry, these three. Palak Modi for that para 25, that Krishna Iyer judgment para 54, and para 28 of Chandra Prakash Sahi. At page 167. The important principle
You're relying on para?
28, madam.
Yes.
At page 167. The important principle which are deducible on the concept of motive and foundation concerning a probationer are that a probationer has no right to hold the post and his service can be terminated at any time, kindly mark the word, during or at the end of the period of probation on account of general unsuitability for the post in question. If for determination of suitability of probationer for the post in question, or for his further retention in service or for confirmation, an inquiry is held, and it is on the basis of that inquiry that a decision is taken to terminate his service, order will not be punitive in nature. My lord, my learned friend has given offered, have been placed before lordships the suitability assessment report of the vice chancellor, based on which my lord executive council took the decision. It was basically to find him whether he is to be retained or his if this further period of probation should be extended. I'm reading it once again. If for the determination of suitability of the probationer for the post in question, or for his further retention in service or for confirmation, an inquiry is held, and it is on the basis of that inquiry that decision is taken to terminate his services, the order will not be punitive in nature. But if there are allegations of misconduct and an inquiry is held to find out the truth of that misconduct, and an order terminating the service is passed on the basis of that inquiry, the order would be punitive in nature, as the inquiry was held not for assessing the general suitability of the employee, but for the post in question, but to find out truth of allegations of misconduct against the employee. It is in this situation the order will be founded on misconduct, and it will not be a mere matter of motive. So, my lord, if my learned friend is to succeed in his attempt, he will have to demonstrate that this inquiry was not for the purpose of finding out his suitability, but it was an inquiry to find out whether he is guilty of any misconduct. At least, my lord, the agenda item and the discussion which has taken place, which has preceded the impute decision, my lord, does not say so. My lord, I'll place the original record. Original record is nothing, but is the part of the same very suitability assessment. I'll just read one paragraph from that, my lord. Of course, I'll hand over the file. If your lordship would kindly have that agenda item 19, my lord, which was placed by my learned friend.
Agenda item?
My lord.
19.
Yes. Sorry, this is first, my lord, will have the VC's assessment, my lord.
Yes.
Please come to the last page, last but one para. After referring to various acts of omission and commission, having considered the responsibilities and the decorum which is expected from the post, I am of the considered view that further retention of Dr. Guru Prasad Khatuniar in the post of Registrar of University would not be beneficial for the university on the ground of his general unsuitability to hold the post in question. Further, Dr. Khatuniar is on probation and therefore relieving him from the post of registrar at this stage without commenting on veracity of the allegation or without raising question on his character or conduct, and by keeping the better interest of the university in mind, would not hamper his future prospects in any manner. I would, in view of the above, recommend that provisionary services of Dr. Guru Prasad Khatuniar as registrar of the university be discontinued in the interest of university, considering his general unsuitability to hold the post while ensuring his liberty to go back to Guwahati University as he is still holding the lien therein. My lord, is the language used in the report of the Vice Chancellor is suggestive of my lord trying to find out whether he is guilty of misconduct, or my lord, a general assessment was made regarding his suitability to be retained in the university? Though there is a thin line of distinction, my lord, that distinction exists, and I will respectfully submit, lordships would recognize the distinction between them. So, my lord, this is the view of the Vice Chancellor. He says, having regard to his various acts of omission and commission, I don't think he is fit. My lord, this is absolutely permissible. It does not cast any aspersion. It does not cast any stigma. Then eventually, my lord, at item number 9, agenda item number 19. After referring to all this, my lord, a resolution. The Executive Council of Bhattodev University unanimously resolved to relieve Guru Prasad Khatuniar from the post of registrar of this university with effect from 1 to 23 as per provisions under section so-and-so of the first statute on the ground of his general unsuitability to hold the post, and it further resolved that he be released from services of Bhattodev University on the same date through a written communication. The House further resolved to direct registrar in charge to initiate process for advertising for the post of the registrar after consulting so-and-so of the university. Of course, my lord, this part of the resolution was stayed while admitting the petition, issuing notice regarding, that is how the matter stands. We issued the advertisement, but this honorable court said that during pendency of the notice, the advertisement should not be acted upon, and we have not, my. So, my lord, under these facts and circumstances, to bring in the general law of my lord, provision and my lord, confirmation, qua motive and foundation, in my humble submission, is absolutely fallacious. There is no stinge of any, my lord, imputation which can be attributed. It's a pure and simple case, my lord. There is no dispute that the gentleman was arrested taking bribe. He was caught red-handed. I, as an employer, I'm not inclined to keep such a man. I don't want to investigate either whether he is actually guilty or not. But I am satisfied I will not keep this man. And that is one liberty which Honorable Supreme Court has recognized at the hands of the employer. And that is paragraph 54 of my lord, Gujarat Steel Tubes. There are allegations. I'll not go into the veracity of it, but at the same time, I'm convinced I'll not keep this man. Pass a simple order of termination and relieve him. But these are my submissions. Basically, it's a pure and simple case where is no stigma is cast, and there's no prejudice would be caused to him, my lord. He has his lien over his substantive post in Guwahati University. He can join tomorrow. There's no difficulty. He says 5th of May. Why should wait up to 5th of May? He can go tomorrow. That is my humble.
Lordship may like to pay.
Yes, the record.
The recommendation of the VC and the resolution I have flag marked.
Yes.
My lord, I appear for the respondent number 8, the Vice Chancellor, who has been made a party by name. Initially, my lord, there were
Made a party, but no submission.
no submission. So that is my first submission. There were certain allegations of malafide. We replied, and during the course of arguments, those allegations have not even been urged. So your lordship will kindly record that they have been given up.
You're for respondent?
8.
So Lordships kindly, my lord, there is a matter in court number 10.
Yes, yes, please. Please. Yes.
So now that leaves us with a situation where your lordships would be testing the arguments on merits, dehors any allegation of malafide. In those circumstances, I'll quickly just supplement what my respected senior friend, Mr. Ken Chaudhary, has submitted. But the entire thrust of the argument has been as if there exists a legal right, and that right has been violated. As a probationer, there is no such right. One of the first principles pertaining to the law relating to a probationer, the only limited right that has been recognized is, that is where perhaps the petitioner has got a little confused. The only limited right that has been recognized by the Supreme Court is, as my learned friend Mr. Ken Chaudhary was pointing out, in case there are allegations and the authorities intend to find out the correctness or otherwise of those allegations. And for that purpose, if an inquiry is held, it is only then that he will be entitled to an opportunity. So virtually what has actually happened is the petitioner has confused between these two terms, inquiry and assessment. So these are entirely in the context of the law relating to a probationer. These two words carry distinct and different meanings. When an inquiry is held for the purpose of determining the correctness, the veracity of the allegation, it is in that inquiry that he will be entitled to an opportunity. But if the authorities decide that he is merely a probationer, we don't intend to go into the correctness of these allegations. But on account of these allegations themselves, we would not like to continue. For that, an assessment will have to, the moment an assessment, and that had in fact already fallen from your lordship. For the purpose of making an assessment, the period during which he has served, his act and the manner in which he has conducted himself will have to be assessed. That assessment is permissible. But if they inquire into whether this particular allegation, whether in this case, one of the allegations is there is an FIR based on which a criminal proceeding has got initiated. The allegation is that he was caught red-handed taking a bribe. We could have very well, had it been a substantive employee, we could have very well conducted an inquiry of our own to find out whether he actually took a bribe or not. Here we are not interested. There is an allegation that he was caught red-handed. That is sufficient. The Vice Chancellor very specifically in his report says that we are not going into all this. But these acts of his during the period that he served as a probationer, we are not satisfied. And we are not going into the correctness or otherwise, would not like to keep such a. And that is why, in fact, one judgment I'll place, where in fact one of the submissions advanced by my learned friend was that the order, impugned order, does not even record that his services have been found to be satisfactory or unsatisfactory. In fact, in one particular case before the Supreme Court, what happened? It was recorded that it is not satisfactory. And that was questioned by saying that since you have recorded that you have found my services to be unsatisfactory, this casts a stigma on me. Even that was negated. But that judgment, it's a very short judgment. I'll place that one. This 2002, volume 9 SCC. Volume 9 SCC 636. It's a very short judgment. State of Punjab versus Bhagwan Singh.
Yes.
Just, it's a very, very short judgment, Malab. Paragraph 3, the order impugned itself is extracted. And your Lordship will kindly have a look at the language. It talks about the act, conduct of the person concerned, officer concerned, the probationer concerned. It also specifically records that it is not satisfactory. May I read it, Malab? The impugned order dated 4/9/92 was passed by the competent authority. It reads as follows. It has been reported to me by in charge of PTC Ladha so-and-so, Inspector Joginder Singh, RI Police Lines, so-and-so, Inspector Sadhuram, so-and-so, that the act and conduct of Constable Bhagwan Singh number so-and-so on the whole is not satisfactory. And he is unlikely to become a good officer, a good police officer. This is the extent to which it has been recorded. I am also satisfied with their reports. I, Jasminder Singh, so IPS, being competent authority, do hereby discharge Constable Bhagwan Singh so-and-so from service with effect from today, that is so-and-so, as he is found to be unlikely to prove a good police officer. And next month, this aforesaid order, to the extent it stated that the officer was unlikely to prove a good officer, was in terms of the relevant rule 12.21 applicable to the respondent. In our view, when a probationer is discharged during the period of probation, and if for the purpose of discharge, a particular assessment of his work is to be made, and the authorities referred to such an assessment of his work while passing the order of discharge, that cannot be held to be to amount to stigma. The other sentence in the impugned order is that the performance of the officer on the whole was not satisfactory. Even that does not amount to any stigma. Learned counsel for the respondent, however, contended that the reference in the impugned order to the reports of the inspectors on the basis of which the above assessment was made would itself amount to stigma. This again cannot be accepted. So here, the person's conduct is being referred to in the impugned order itself. The person, the fact that he is not going to prove to be a good officer is referred. Even that was held to be not.
Is it dealt with by the subsequent judgments?
No. This is a very short, it is purely on the facts of that case. Obviously, the law, there is another judgment also, 1997, 2 SCC 191, on the same issue. The idea is, my lord, for the purpose of making an assessment, certain things will have to be taken note regarding how he conducted himself during the period of his period that he served as a probationer. Referring to that per se will not amount to casting a stigma, as long as the order itself is a termination simplicity. Because these are merely internal records for the purpose of assessment. And in fact, there is another judgment on similar lines. This is also a very short judgment. 1997, volume 2 SCC 191. this is also on similar lines, that for the purpose of making an assessment.
But will it not give, I mean, if what you're submitting is that for the purposes of making an assessment, whatever information you want, you can take it. And some reports saying that he's not suitable or certain deficiencies have been reported.
Well,
what is the protection of the employee concerned?
In fact, my lord,
Are
that
you
is
saying that there is
that
no
is
protection?
that is the peculiar thing in case of a probation. In respect of all others, the principles of natural justice, like for example, even in a disciplinary, when a substantive employee is faced with a disciplinary proceeding,
But a provisioner released for this is bound to have consequences later in his career somewhere.
No, I will place those other judgments also. What happens is, the very idea of keeping a man on probation, right from one of the 60s, this.
No, that's quite right. That you have to make an assessment of how he rendered his services, whether he's suitable, etc., etc. But the question is, the probationer is not confronted with any of these deficiencies.
It is not required. That is the law. That is
the question which I'm asking you, is that the law?
Yes. In fact, I was about to come to those judgments.
Yes.
In that case, let me place that. I won't trouble this other judgment that I referred to, 97, is absolutely on identical lines. So I'm just giving the citation, 1997, volume 2, SCC 191, para 5. But I won't trouble your lordship with this, but let me come straight to your lordship's query. 1999, volume 2, SCC 21. This is Radhesham Gupta. This again refers to all the.
This is page number
99 2 SCC 21. And the paragraph that I am relying on is para 33. Here also, my lord, an elaborate discussion of all the case laws continues till paragraph 32. And the conclusion is recorded at para 33.
You're not furnishing the list of books. It makes it convenient for us to categorize.
No, list of books has been furnished.
Is it?
In the morning itself.
Anyway, are you also relying on Radhesham?
No.
My lord, the judgment that Chandra Prakash Shahi that I relied on contains all the judgments, my lord. Relied upon by my senior Mr. K. N. Chaudhary as well as me.
I'm just asking you.
No,
You're also relying on Radhesham.
No, I have referred to those paragraphs wherein Radhesham was relied.
Yes, para 33.
Para 33. Till para 32, all the judgments are referred to right from the beginning.
Yes. Yes.
Now, para 33. It will be noticed from the above decisions that the termination of the services of a temporary servant or one on probation on the basis of adverse entries or on the basis of an assessment that his work is not satisfactory will not be punitive, inasmuch as the above facts are merely the motive and not the foundation. The reason why they are the motive is that the assessment is not done with the object of finding out any misconduct on the part of the officer as stated by Shahjeh, as he then was, in Ram Narayan Das. It is done only with a view to decide whether he is to be retained or continued in service. The position is not different. Even if a preliminary inquiry is held, because the purpose of the preliminary inquiry is to find out if there is prima facie evidence or material to initiate a regular departmental inquiry. It has been so decided in Champaklal case. The purpose of the preliminary inquiry is not to find out misconduct on the part of the officer, And if a termination follows without giving an opportunity, it will not be bad. Even in a case where a regular departmental inquiry is started, a charge memo issued, reply obtained, and an inquiry officer is appointed. If at that point of time, the inquiry is dropped and a simple notice of termination is passed, the same will not be punitive because the inquiry officer has not recorded evidence nor given any findings on the charges. That is what is held in Sukra Bahadur and in Benjamin case. In the latter case, the departmental inquiry was stopped because the employer was not sure of establishing the guilt of the employee. In all these cases, the allegations against the employee merely raised a cloud on his conduct, as pointed out by Krishna Iyer J in Gujarat Steel Tubes, that has been placed by my learned friend Mr. Chaudhary. The employer was entitled to say that he would not continue an employee against whom allegations were made, the truth of which the employer was not interested in to ascertain. In fact, the employer, by opting to pass a simple order of termination as permitted by the terms of appointment or as permitted by the rules, was conferring a benefit on the employee by passing a simple order of termination so that the employee would not suffer from any stigma which would attach to the rest of his career if a dismissal or other punitive order was passed. The above are all examples where the allegations whose truth has not been found and were merely the motive. So, Malab, what this law pertaining to probation, like the law of reservation, Malab, it took me a lot of time to understand, and I'm yet to understand wholly. But with my limited understanding, as I have been able to gather, even as this judgment itself in paragraph 33 says, even when a proceeding is initiated, a show cause is issued, the employee concerned gives a reply, even charges are framed, even at that stage, the authorities may say that we will not inquire into this. We don't want to know the truth.
No dispute on that. See, the question is, once you make an inquiry,
well,
you as an employer will have access to, let's put it that way, that hypothetically, you may have all the circumstances in your favor to develop a case or to bring out a case completely against the provisioner. What defense does he have against that?
Nothing.
As per your submission, nothing?
Nothing. Because that is what is not required. For a probationer, the law is, when it comes to a probationer, the law is that you do not enjoy any right of a substantive employee. You have been kept on probation because the whole idea behind keeping a man on probation
is how does the court decide on the correctness of his assessment?
No, even assuming, let me take it a little further. Even assuming your lordship goes into, although how far that would be permissible in exercise of judicial review is also again another aspect. Assuming materials emerge that he actually did not take the bribe, or he actually, all the allegations.
Not on that. Where you're right, you have given the ground of his unsuitability.
Yes.
According to him, he has never been confronted of his deficiency.
Absolutely, absolutely.
While of course he has not pleaded very specifically that these are all baseless. But are you saying that there is no judicial courts have no power, are not even required to go into this aspect of finding out, even when a citizen is clamoring for justice?
Yes. In case of a probationer, that is the law. Assuming, that is why I was assuming your lordships find from the records that the materials based on which the assessment have been made are all incorrect. Absolutely, all the materials that we have relied on are.
Then how do you connect later judgment where it says that you may be permitted to leave the veil?
Yes, your lordship will lift the veil in case We have conducted an inquiry. That is why I started off my submissions by making this, trying to make this distinction that if we conducted an inquiry to find out whether these allegations against him are correct or not. Assuming hypothetically there is an allegation against him that he never reaches the office on time. These allegations may not be absolutely correct. Out of the 10 days, he might have visited the office on time at 10 o'clock, 9 out of 10 times. We, as the employer, we are wholly entitled to say that there is this allegation against him. Whether correct or not, we are not bothered. We are discontinuing. So that is this thin line in case of a probationer. Unless we conduct an inquiry to find out the correctness, there's no legal right at all. And in my humble understanding, my lord, that is the law. In fact, this paragraph 33, if your lordships see, even if a preliminary inquiry is held without giving an opportunity, and the authorities say that no, we are not going into a full-fledged inquiry, we simply terminate it. That is permissible. When charges are framed, may I read that portion once again, Mal? Here, the apex court has made the position very, very clear. The only test is whether we have in the impugned order, whether we have attached a stigma or whether we have done it as a punitive measure.
What is general unsuitability? How do you define general unsuitability?
General unsuitability is the various assessments that we made, the various things that we saw in traits that we saw in him.
Okay.
Oh, there's another judgment, my lord, 2006, volume 7 SCC 5.
For what proposition?
Same principle, my lord.
No. For one judgment is good enough. Why you
no
giving us?
On this, my lord, here is again a case. Why I wanted to point this out is here inquiry was initiated and then wrong. Just
no, there is no quarrel on this fact that you may not like to go into the veracity of the allegations. So in that case, you proceeded, then you decided we would not like to know. Even then, it was held to be proper. We are not on that. The only thing that is troubling us is that you decided to make an assessment.
In case of a probationer, there is always an assessment, even either for confirmation or for
correct. He's not just any employee, he's a registrar of the university. So therefore, you proceed to make an assessment after 3 or 4 months or 5. And then you find the unsuitable.
Yes.
When, as projected by him, his period of provision is for at least 1 year. That period admittedly was not complete. So what is that ground on which it required assessment of his suitability within a period of 4 months?
But again, on that point also, the law is...
Besides the fact that he was arrested.
On that issue also, the law is very well set. The judgment has paragraph 28 of Palak Modi, which has already been placed. Para 25 of Palak Modi. And there are other judgments prior to this also. Even in Chandra Prakash Shahi also, I think in para 28, Supreme Court has said that it is during the period. Again, in this particular case, leaving aside all other aspects, rightly or wrongly, here is a registrar of a university who has been arrested on the allegation of taking a bribe and being caught red-handed. This happened within a period of the first 3 months. It will be stretching it a little too far to expect the employer to wait for the entire completion of 1 year. Because here is a man, there is an allegation against him. And this is a new university which has come up. We would like to take care of our reputation also. So that is why we feel that an assessment is necessary. We did the assessment. And while doing the assessment, we found that there were various other aspects of his service which we did not find satisfactory to our satisfaction. The principle of law, again, as has been held in Palak Modi, the language used is this one. The ratio of the above noted judgments is that a probationer has no right to hold the post and his service can be terminated at any time during or at the end of the period of probation on account of general unsuitability for the post held by him. So, on this, my lord, the fact that at any point of time during the period of probation he can be terminated, there is no quarrel on this issue at all. This has been laid down right from Samsai Singh onwards. The law is very clear. Now, the only question is, he is trying to, that is why, again, at the cost of repetition, the confusion arises in case of probationers is because the moment we go to a substantive employee, this problem does not arise at all, and hence no confusion. In case of a substantive employee, there is no question of an assessment. The assessment may be only for the purpose of giving his ACR remarks, but not for the purpose of keeping him or discontinuing. But when it comes to a probationer, there is that assessment which is required to be done, be it for the purpose of confirming him or be it for the purpose of discontinuing. So either way, we have to make an assessment. While making the assessment, we have to, in our internal notings, we have to say, we have to make an assessment of how does otherwise a person's assessment, how can the assessment be done? We have to look at how he has performed. We find that he is, if we find that some employee is irregular in his attending office, he is not up to the mark in doing his work, various aspects. So far as a probationer goes, my lord, the right is virtually non-existent.
There's no quarrel that there is no right. There is no right, but subject to what we come to hold. Either you say that yes, general unsuitability is defined in the statute or in the rules.
There's no, because it is as the word suggests, it's general unsuitability.
So general unsuitability gives a room for a lot of high-handedness to the employer.
Because that is why, my lord, I was trying to stretch it to the other extreme. Assuming nothing is in this particular case, there are certain assessments made, which your lordship will find in the records. Records will reveal that there are various aspects which were assessed. Assuming one employer does not even bother to say anything, just one line, we find him generally unsuitable. There is no material to substantiate that. Even then, the probationer would not have any right because he is on probation. And it is not that we thrust it upon him. He was aware that he is on probation, and that is why your lordship always, lordship is aware.
That argument is self-defeating because the whole purpose of putting a person on probation is to find his suitability. Now, if you say he is unsuitable and you have no means to say so,
we have the means. That is why we have recorded.
What was the need for what was the need for creating a post on probation? The purpose of probation, put somebody on probation, is to see whether the person is suitable to be permanently absorbed.
Precisely.
So either you give reasons to say that yes, he is permanently suitable because of X, Y, Z, or you say no, he is not suitable.
And that is what has been done.
Now, if you say he is not suitable, without any reason, it defeats the very purpose of.
No, we have recorded the reasons in the file.
You have reasons, well, we'll go through it. Go through the reasons. This is to think aloud the submission which came from you that even if the employer says no reasons, we find him generally unsuitable. That would go contrary to the very concept of a provision. Why have a provision at all?
No.
Why have a provision period at all?
My lord, in that case, my lord, may I try to answer your lordship's query? The purpose of probation is, as has fallen from your lordship, is to find out the suitable. Otherwise, we would have immediately appointed him on substantive capacity. We give him that time, and for unlike a fresh appointment, here is a case he already holds a lien. Your lordship is aware no person can have a lien on two posts. He already has a lien at Gaudi University. Now he is brought on probation. We would like to see whether he would be suitable to function as registrar of our university. And we find within a period of 3 months, various things that have been attributed to him, we find that he is not suitable. And we have, while making the assessment, we have recorded all these. It's just that the test is, in the order, if we mention, it immediately takes the color of a stigmatic order. So therefore, my lord, in my respectful submission, this is a case where
So you have the reasons, but you don't want to mention it in the order.
we cannot, because that is the law again. The moment we mention it, it becomes stigmatic, and then we will have to give him a notice. That is the law relating to probation. If your lordship so desires, my lord, I can start from right from Sanjay Singh. The moment we attach, there are two situations when the order becomes would stand vitiated. One is if we attach a stigma. The moment we say, had we said it in the order that this is the reason that you have been caught red-handed taking a bribe, had we mentioned that, assuming, it would have cast a stigma on him, and then natural justice would have come up. Or had we said that for XYZ reasons, we found your service to be unsatisfactory, then it would immediately become punitive. So therefore, and these are two areas, my lord, we have to be very careful as an employer. We cannot prejudice his future employment. That is the test.
You're right. Yes.
Yes,
This is a matter of law. Does it require any?
factual determination is not there, not required, my lord. But one thing I'd like to clarify, the submission made by both the seniors, my lord. That one submission has been sought to be made, whether there is inquiry or not, whether there is preliminary inquiry or not, whether a DP has been initiated or not, and DP has been dropped. Even then also, my lord, the order has been stated to be simpliciter by the Honorable Apex Court. My lord, the judgments that I have placed or I have read, my lord, in preparing the case, what I have understood is that in some case there will be an inquiry and it is stopped midway and termination order. In some case there may be an ex parte inquiry without the presence of the officer. These facts will vary in each case. But what I have understood is that, my lord, but what I have understood is that what the Honorable Apex Court has held, lifting of veil, motive and foundation. The courts have to see whether the termination is founded on any misconduct or not, whether you have conducted the inquiry or not. Lifting of veil from the records, correlated reading with the termination order, what is the outcome? That the Honorable Apex Court has held. The submission made by my senior, Mr. K. Chaudhary, that I may not like to go for inquiry. Fine. You may not like to go for inquiry. But if the record reveals that there are elements of misconduct in the stipulation, then the court will come into play and court will not exercise its power.
Yes.
Second query, that a query has been raised by your lordships, that what right the probationer has. I have already relied on Chandra Prakash Shahi. Therein, Milord, at para 24, the Honorable Apex Court, relying on Ravindra Kumar Mishra and UP State Handloom Corporation Limited, very specifically state, 4 lines, I'll just refresh your lordships, nothing more than that.
Yes.
It was observed, lordship may not like to refer, just lordship will just, I'll just read.
Which paragraph?
Para 24.
Yes.
Last line, my lord. Motive foundation, I am not reading, my lord. Lordship is aware of this. It was observed by this court that in the relationship of master and servant, there is a moral obligation to act fairly. There should be an assessment of the work of the employee, and if any defect is noted in his working, the employee should be made aware of the defect in his work and deficiency in his performance. Defects or deficiency, indifference, or indiscretion may be with the employee by inadvertence and not by incapacity to work. Timely communication of the assessment of the work in such case may put the employee on the right track. Without any such communication, it was observed, it would be arbitrary to give a movement order to the employee on the ground of unsuitability. So that is the answer to the query raised by your lordship. And one submission.
Yes.
Look, one submission has been made by my senior counsel, my senior Mr. K. N. Chaudhary, relying on para 4.2.3.2. That a review can be done at any time. I have already read its shell.
Your submission was that it ought to have been done after completion of 1 year.
Fine. Even assuming, I'm just extending it, even assuming the submission of the senior counsel to be correct, fine, you can. But this 4.2.3.2 doesn't give you power to terminate. The power has been on 4.2.2.3. And the moment you rely on 4.2.2.3 in the impugn order,
yes,
the grounds mentioned therein necessitates an inquiry. It doesn't give you power. 4.2.3.2 doesn't give you power. It says only it's a condition of service review. But 4.2.2 heading is term of office. And how to get rid of this registrar? 4.2.2.3. So what is the difficulty? If you are so confident that the purported allegations that the VC recorded in his recommendation are so strong, so what is the difficulty in holding the inquiry? Why this shortcut method of Milord?
The contra argument could have been, or which they would have made, is that this is 4.2.2.3.
Implied.
No.
Not
implied.
Sorry, I'm sorry.
Is to be applied to the case of a registrar post confirmation.
Exactly.
Yes.
Once you are confirmed, the only way to remove you is 4.2.2.3. Here you are a case of a probationer. So once you are a probationer, you are not really an employee. in that sense of the matter.
So they should not have relied on 4.2.3.2.
Reliance of the
4.2.2.
clause by itself.
They basically, my lord,
Unless you want to say that there is no provision for, even for a probationer, it is the clause of 4.2.3.
yes, because they invoke power of 4.2.2.3 assessment and the grounds, everything has been used by them. So if you use those grounds, then it's inevitable. My lord, two more judgments I just found, my lord. I'll just mark the paragraphs, my lord. I'll not read. Lordship will kindly have a look.
For what proposition?
My lord, this is motive and foundation, my lord. Samsher Singh, Lordship, I gave the relevant paragraphs earlier. Samsher Singh's judgment.
Okay.
So, my lord, my humble submission is that, my lord, this writ petition deserves to be allowed. Quashing the termination order, he is entitled to be reinstated with full back wages. Back wages judgment, my lord, I have given already. And one more thing, my lord, in the IA we have challenged the advertisement. So, in view of, my lord,
There is a stay.
There
There
is
is a stay on the advertisement.
Order dated
So,
10 February 2023, the advertisement was stayed.
So the petitioner is entitled to reinstatement in his service. That is my humble submission.
A quick response
Deeply
to what has
obliged.
come. He did not make this argument in his initial thing. This reference to clause 4.2.3.2 to say that this does not confer power of termination. There is a judgment of the Supreme Court which says appointment on probation inheres in itself the power to terminate. That I'm just not giving the citation, madam. The answer to his new submission that he has made in reply. It is Purushottam Lal Dhingra. Year 1958 Supreme Court, 36, and the relevant paragraph is paragraph 11. Appointment on probation by implication, necessary implication includes the power to terminate. That is why the word probation. And also, the General Clauses Act is always there.
Yeah.
So,
not reserved.
Only one small prayer, my lord. Lordship
Before
will
fifth.
Yes, my lord.
My lord,
Highly obliged.
Guwahati University is a formal party. He has not returned back as yet.
You want him or you don't want him?
He's on lien up to 5th May. So, my lord,
Do you extend his lien? Why don't you extend his lien?
My lord,
Why don't you extend his lien?
no, my lord, he is still on lien up to 5th May.
That's right. So why don't you extend it?
He
Why
has
don't you
not applied
consider
for-
extension?
he has not applied for extension, I understand.
No, I can apply. There is no bar.
He was authority devoted.
Okay.
Also have to take a decision.
It has become a nightmare.
If he comes back, there will be another chapter.
They are in some different mood. It appears.
You seem to be a favorite of both the universities.
I have the feeling otherwise, my lord. When my senior has said we'll have to also examine whether to.
That is also something to come
Okay. Thank you. That reserved.
Obliged.
Deeply obliged. Highly obliged.